Yes.
This is a read challenging the award passed by the permanent Lok Adalat. This matter.
So please file the memo. File the memo in the registry. I know that I have all read your assignments. Yes, since
This is
it
a
would be
read
assigned to some
challenging the
bench, so please
award passed by
file it
the
in the registry.
permanent Lok
The
Adalat.
listing mechanism is so please file the memo. File the memo in the registry. I know that I have all read your assignments. Yes, since
This is
it
a
would be
read
assigned to some
challenging the
bench, so
award
please
passed by the permanent Lok Adalat.
listing mechanism. So please file the memo. File the memo in the registry. I know that I have all read your assignments. Yes, since it would be assigned to some bench, so
award passed by the permanent Lok Adalat.
listing mechanism. So please file the memo. File the memo in the registry. I know that I have all read your assignments. Yes, since it would be assigned to some bench, so
award passed by the permanent Lok Adalat.
listing mechanism. So please file the memo. File the memo in the registry. I know that I have all read your assignments. Yes, since it would be assigned to some bench, so
award passed by the permanent Lok Adalat.
listing mechanism. So please file the memo. File the memo in the registry. I know that I have all read your assignments. Yes, since it would be assigned to some bench, so
award passed by the permanent Lok Adalat.
listing mechanism. So please file the memo. File the memo in the registry. I know that I have all read your assignments. Yes, since it would be assigned to some bench, so
award passed by the permanent Lok Adalat.
listing mechanism. So please file the memo. File the memo in the registry. I know that I have all read your assignments. Yes, since it would be assigned to some bench, so listing mechanism. So please file the memo. File the memo in the registry. I know that I have all read your assignments. Yes, since it would be assigned to some bench, so listing mechanism. So please file the memo. File the memo in the registry. I know that I have all read your assignments. Yes, since it would be assigned to some bench, so
supplemental What do you want, sir? The learned counsel section lecons the learned counsel submits that sorry. For the appearing in section 8 Devaras Mahanti for the learned counsel section lecons the learned counsel submits that sorry. For the appearing in section 8 Devaras Mahanti for the as for assignment the learned counsel section lecons the learned counsel submits that sorry. This bench is the assigned bench for the apparently the petitioner doesn't want to appeal the matter stands adjourned. This is the assigned bench. This bench is the assigned bench. Young man, you should be particular while submitting. This is the every day these kind of things were young man, you should be particular while submitting. So in the every day these kind of things were young man, you should be particular while submitting. Number 2. So in the yes, these kind of kindly speak to the microphone. Yes, you are getting muted. So yes. So how do you say that these matters are not assigned? Yes. So kindly speak to the microphone. Yes, you are getting muted. Yes. So how do you say that these matters are not assigned? Yes. So kindly speak to the microphone. Yes, you are getting muted. So having assignment, you are praying this bench as assignment not assigned. Your prayer is that I will assign to assigned bench as if I am the roster bench. Roster bench is the honorable chief justice. You are praying this bench as assignment not assigned. Your prayer is that I will assign to assigned what you are saying as if I am the roster bench. And every day I have to repeat this thing. Yesterday a senior person also mentioned that. You are praying this bench as assignment. So every writ petition, that is how you need to mark all kinds of writ petitions as if I am the roster bench. And every day I have to repeat this thing. Can I direct that for the assignment? You are praying this bench as assignment. So every writ petition, that is how you need to mark all kinds of writ petitions. Unless I am not interested to do them. Every day I have. Why should I not be interested? Can I direct that for the assignment? Please. Every writ petition, that is how you need to mark all kinds of writ petitions. Unless I am not interested to do them. Every day I have. Why should I not be interested? Can I direct that
Holding of her power as a headmistress.
Please. But legal heads can be substituted to do the salary or it is regarding the post. Regarding the post, obviously. But legal heads can be substituted. Mr. Sorojananda Mishra Sorojananda Mishra for salary or petitioner. Mr. Regarding the post. Regarding the post, Sanjeev Sai Mr. Sorojananda Mishra Director Secondary Education for salary or petitioner. Mr. Regarding the post. The learned counsel for the petitioner files memo of date indicating that the petitioner has passed away in the meantime. Unfortunately, passed away in the meantime. Regarding the post. The learned counsel for the petitioner, the learned counsel memo of date indicating that the petition alleges non-compliance of the order dated 17 December 2021. Regarding the post. The learned counsel for the petitioner, the learned counsel memo of date indicating that directing to dispose of the representation order dated of the petitioner 17 December 2021. Regarding the post. The learned counsel for the petitioner, the learned counsel presenting to give her posting as headmaster. Dispose of the representation order dated give her posting as headmaster in charge. Direction टा कौन थिला आपण को प्रेयर टा सॉरी डायरेक्शन को रिपीटेशन ने प्रेयर कौन थिला गिव हर पोस्टिंग एज हेडमास्टर प्रेयर टा सॉरी डायरेक्शन को रिपीटेशन ने प्रेयर कौन थिला गिव हर पोस्टिंग एज हेडमास्टर प्रेयर टा सॉरी डायरेक्शन को रिपीटेशन ने प्रेयर कौन थिला गिव हर पोस्टिंग एज हेडमास्टर प्रेयर टा सॉरी डायरेक्शन को रिपीटेशन ने प्रेयर कौन थिला गिव हर पोस्टिंग एज हेडमास्टर sorry direction repetition le prayer kon thila give her posting as headmaster prayer ta sorry direction repetition le prayer kon thila give her
And this has been discussed earlier also. In some cases, I have asked them. So they have also pointed out that all assignments, maybe 50 or 60, it doesn't matter. And now looking at you should have, when any court, because why I told you to this, suppose you go to another court, make this submission, the court will get irritated. You want adjournment, but for that you will tell the court that you don't have assignment. Please appreciate that also. So this habit of not referring or not reading ends up in trouble. At least if you would have referred to the assignment, then it would have, something would have crept to your mind. You could have asked your senior that there is no specification. Number two, some single judge writ matters. So every matter. And you see how much time you have spent of the court for no reason.
I will be permitted to mention, my lord, I have
Yes, Mr. Naik.
My lord, I am in BC, my lord.
I files this case for the second time. The petitioner challenge if the matter relates to the regularization of his service. But he challenges the order dated 16/1/2025 and also the order.
You take notice, Mr. Naik.
My lord.
What is the grounds of challenge? Annexure 1 and Annexure 7. Why, according to you, they are bad in law?
Because they are questioning the BED certificate. BED certificate, my lord.
Which paragraph of the impugned order? Kindly refer to that.
Annexure 1, my lord.
Page, sir. Page and paragraph. Kindly refer.
Annexure 1, page 16.
Yes.
The petitioner, my lord, second paragraph, the petitioner having...
Regarding BED certificate, where the order deals with that and how you are agreed. Kindly show that.
No, order was not.
You are saying the matter is regarding BED certificate. So
Because
the order you are challenging where it has dealt with BED certificate.
My lord, I have possessed the BED special education, my lord. That is equivalent to BED.
Sir, I am not asking what is your qualification.
My lord.
You are seeking mandamus to set aside an order. You are agreed by an order. You say that the order has not dealt with or dealt with wrongly the issue regarding BD certificate.
Yes, they are
Which
not-
portion of the order? Kindly show that. I am asking you for the last, say, few seconds or a minute. Please find out that. Page 16, top.
16.
The advertisement said the eligibility criteria. Kindly read that. I have to assist you now.
My lord. A candidate must have obtained bachelor's degree in arts science along with a degree of Bachelor of Education from a recognized university. The petitioner having qualification BA with Bachelor of Special Education in hearing impairments was engaged against TGT Arts post by order number such and such dated 22 April 2013 of DO Koraput after completion of 6 years of continuous service.
Now come to the bottom of the page.
My
Last but one paragraph. That as per advertisement.
requisite qualification for TGT Arts post was bachelor's degree in arts science along with a degree of Bachelor of Education from a recognized university. In the advertisement, there is no provision to accept the equivalent training set qualification.
So that is what aggrieves you. You are agreed by that
Yes.
finding.
My-
Learned counsel for the petitioner.
My
The
submission
petitioner is agreed. You
My-
want dismissal or issuance of notice?
notice.
So please wait. Allow the court
But I am
to do something.
One thing that it is covered by this.
Cover. You see, I don't require any cover as far as fresh matters are concerned. If you are relying on any cover, just say
Yes, that is what I'm
share them with the cover. Let them find out whether the cover covers this.
Exactly. Give me judgment.
The covering order runs to how many? One page.
No, I.
It's a full judgment.
Full judgment. Yes.
Judgment. His prayer in the writ petition that this case is covered by the judgment, so my case be considered. So I have to check out whether actually it is covered or not.
সেটা তাহলে তার কপি ଅଛି ରଖିଛନ୍ତି?
Copy annex କରିଦେଇଥିଲେ annex
କଣ
କରିନାହାନ୍ତି।
କରିବା ସେଟା ଅଛି ଦିଅନ୍ତୁ ତାହେଲେ ଆଣନ୍ତୁ
ହଁ ଦେଲେ।
Extra copy.
Had counsel for the petitioner it is submitted the petitioner is agreed by the order dated
12/4/2020
16/1/2025 passed by the director ରଖୁନ ସେଟା ତ ଛିଡା କାଇଁ ହୋଉଛନ୍ତି ଆପଣ passed by the director secondary education
Annexed to the writ petition marked as Annexure 1 and Annexure 7.
The 7 is the regulation cancellation order.
Annexure 7.
1 and 7.
So 7 is consequential or 1 is consequential of 7?
Fact is different. Annexure 7, it was
It's
initially
1921.
Uh-huh.
13th May 2021.
ତାଙ୍କର ରେଗୁଲାରାଇଜେସନ ଆଗରୁ କରାଯାଇଥିଲା, wrongly it was done. The regulation was cancelled. Cancelled ଟାକୁ ଚ୍ୟାଲେଞ୍ଜ କରିଥିଲେ ରିଟ୍ ପିଟିସନରେ. Thereafter court directed to consider the matter.
You should have pursued that litigation.
Yes.
When you are challenging a regulation cancellation, how could you take the risk of going back without adjudication? This is a classic case where representation disposal leads to more litigation and more time for the petitioner.
Well, here I am.
When you had challenged the order or not, as Mr. Or if you disagree, then that's a different. So then you please kindly don't say anything further. Not 7. 1 କହିଲେ ଆପଣଙ୍କୁ 16 January 2025. Annexure 1.
Yes.
I am discussing with the bar regarding the learned counsel regarding Annexure 7. ଆପଣ ତ 7 ଲେଖିଦେଲେ. Annexure 1. It is submitted that the petitioner is also agreed by the order dated 13th May 2021. Annexed to the writ petition marked as Annexure 7. Wherein his regularization in service by office order dated 8th February para. Thereafter, pursuant to the order passed by this court, the matter has the authority considered the case of the petitioner for regularization and has held as quoted herein. That as page 16 last para. It starts with that as per advertisement, ends with TGT Arts. This part is difficult in paperless. So he's not looking at the brief.
Oh.
So this part is little bit difficult in paperless brief. On likely. Tapare dekhantu, it is further submitted that by the learned counsel that regarding equivalence of a judgment account equivalence
Equivalence.
regarding equivalence of the
BD certificate.
Regarding equivalence of training qualification for the TGC Arts post of the petitioner's qualification, that is BA with Bachelor of Special Education.
In hearing impairment.
Whatever. Special education, maybe hearing visual impaired, hearing impairment, more locomotor disorder, there can be so many. What like that? Sentence ta pura padho.
Ask for on the petitioner qualification that is BA with
Bachelor's degree in special education remains no more res integra, as has been decided by a coordinate bench of this court by order dated 12/4/23. passed in WPC number 1017 of 2022 into bracket Sambit Rekha Jena versus state. By the said order, this court has held that the qualification of special education, special education has been held to be equivalent to bachelor's in arts.
BD. Equivalent to BD.
Equivalent to.
Your Lordship may not given question in the matter.
Okay, ठीक है. कौन लिख ले? Remains no more resident has been resident का. तापर कौन लिख ले?
That has been decided by the court based on this court by other defense.
जोटे आपको डाउट होची आपण पचार दो हला हम रिपीट कर समय नष्ट होउनी. WPC नंबर एते तापर पार्टी ना लिखले स्टॉप क्रिटिक कर दियो. The learned counsel for the petitioner subs a copy of the order, said order, on the learned AGA. Issue notice along with this order. The learned AGA appears. The learned AGA upon advance copy sought appears on behalf of the opposite parties. Waives notice. Required extra copy?
No.
The learned AGA seeks. The learned AGA shall obtain instruction and file counter.
4 weeks.
How much time? List after 4 weeks. The copy दे देले तुमको.
दौच.
सेटा दे दो नांदी.
हां सेटा दे देछि किंतु आगुरु ए जो रीड पिटिशन रो कॉपी टा बर्तन आउड दे दोछि. गोटे देछि.
Read copytion there because of this LMS system. So read petition copy like it was done in every time also. But LMS is about 20 years old system. Quite old.
Item 3.
Mr. BK Parda 2.
My lord.
BK Parda 2 for the petitioner. Mr. Sanjeev Swain. AGA for the state. Yes, Mr. Parda, please.
My lord, second time litigation. Limited prayer for
First time कौन representation नहीं थिले?
representation and dispose of order.
Second time हबो आगे.
Second time सुननाते ये order किसी सुननाते बताना collector.
This order is not appellable.
No.
I'll record some. If you take that risk of stating that this order is not appellable, I'll record that submission that not appellable. They will obtain instruction and it is up to you to take that risk there.
Only prayer for my representation consider.
Sir, in revenue matters, representation has no role. It is not discretion of the authority. It is a statutory right.
I know.
You have all the. You are officer of the court. You are fighting for right of the individual, and you are saying representation in a revenue matter. And you have to be clear in your statement that it is not appellable. If it is appellable, they come back, then it will be dismissed. Don't convert. You see, the interesting part is that now even RI's order is being challenged in writ petition. The High Court has been converted to that of a Tahsildar. And it is not at all efficacious because writ court cannot go into the facts.
Arjun, I will take instruction on that, sir.
Instruction जान नियंतु आप कौन करिया?
It will be Arjun.
चालियो सेमते हो. The learned counsel for the petitioner, it is submitted that the petitioner is aggrieved by the inaction of the opposite party authority. ଆପଣ କଣ କୋ capacity ଚାହୁଁଛନ୍ତି? In which capacity you are seeking settlement of government land? Kindly speak to the microphone, sir. Every time I have to request everyone, kindly speak to the microphone. ଆପଣ ଗାଡୁ ଟିକେ ରଖନ୍ତୁ.
My lord.
Yes.
Poor landless person.
Poor person, they are.
Poor person करो पाई ना eligibility आसीवनी आपनकर landless homesteadless हो दरकार.
Person.
At least you make that statement. कौन लिख ले?
I have made an aberrament in the paragraph, my lord.
Authority in not settling him with government land for which he is entitled, public eligible, being a landless person. Landless person.
Paragraph 5 aberrament.
Sir, that I have already dictated, sir. Now you are interrupting the process of dictation also. I am assisting you, then dictating, then landless person. It is submitted that earlier the petitioner had approached this court by filing writ petition number 15330 of 2022, which was disposed by order dated 24/5/2022, directing to dispose of the writ petition, directing to dispose of the representation of the petitioner. So representation ne kon hela?
ଏପର୍ଯ୍ୟନ୍ତ କିଛି କରିନାହାନ୍ତି
It is submitted that
Now pending.
the representation is still pending as per instructions provided by the petitioner. The learned AG the learned AG shall obtain instructions in the matter regarding the status of the petition, if still pending, and the reasons for not for delay in disposing of the same, and the reasonable time that would be required for disposing the representation if there is no other legal impediment. How much time, Mr. Sahoo?
4 weeks time.
Least after 4 weeks. You can get a positive instruction that it will be disposed of. See, whatever way.
যদি কিছু অ্যাকশন নেই না তাহলে in the meantime
Please, yes, yes.
The entire case
Yes.
is a landless person, they want to settle.
Yes, yes. See, the other difficulty is that the petitioners belonging to Baleswar are landless in Cuttack.
That is
The
fact.
petitioner belonging to Bhadrak are landless in Cuttack. So that is another problem. The investigation,
Inquiry is to be made.
the inquiry has to be made in local inquiry.
Local
Somebody belonging to other state, a landlord, is landless in Odisha. So this is my humble experience while dealing with these matters, as you know. It's not because the statute does not provide that he has to be landless in a particular place.
Yeah.
Because most of the lawyers are landless in Cuttack. They require. It was told by, I think, Justice Indrajit Mahant.
Yes.
How many of us are getting that much of benefit? And it's a professional requirement. His Lordship was referring to the professional requirement that people are struggling here. Yes.
Item 4. May I please, Your Lordship, writ application was filed for not.
Just adjust to the height because it has to be to your height. Raise kar diyo tu. Yes, sir. Please. You are Mr. Das. Mr. Saurabh Das, S. Das for the petitioner. Mr. Sanjeev Swami, AGA for the state. Yes, Mr. Das.
Millard's writ application was filed for not including diploma in special education in the recruitment process for Sebika at the opposite party number.
Similar to the other matter, Mr.
Millard's already corrigendum has been issued. The matter has become infructuous.
Okay. So that corrigendum.
This is under infructuous.
Yes.
That corrigendum will help you in if it is equivalent for Sebika, then why not for teacher?
The other case.
I mean, it may be just a coincidence that in one matter we are discussing the equivalence of special education, diploma in special education. Achha, it is diploma or degree?
Diploma.
Achha. So that is degree.
Corrigendum dated 21/2/2020.
So that corrigendum is available with you?
Millards, I do not have a copy of the corrigendum right now. If the Honorable Court allows, I'll submit. But the corrigendum
will do. If you want to withdraw, let him simply withdraw it.
Let that be on record.
Yes.
Since it is a contested matter,
he has to give a withdrawal petition.
it is a contested matter because withdrawing is at their risk. They are withdrawing at their risk. Mr. Das, it will be res integra for you. You must understand. What is that called?
Corrigendum is annexed at item number 7, 22/1/2025.
7. So let us take up that.
Grateful, Millards.
Item 7 ta ago lekhantu. Item 7, then item 4, tapare kota.
No, Millards, item 7.
There are only 2 matters. No, today how many matters are listed?
2 matters are listed.
So item 7 is
not
Mr. Swai, kindly take up item 7. 4305.
Millards, item 7 is not infructuous. I have annexed the corrigendum in item 7 for a different issue.
ठीक है. Item 7 page कितने?
Millards, item number 7, relevant page number is at page 50.
So Das, you can use the paperless one, like I am doing. I am opening both the briefs.
Well,
No, anyway, it's a suggestion. You should be tech savvy. Page?
well, it's page number 50.
50.
Yes. As
Mr.
revised.
Swaik, just find out 4305, page 50. You are having that?
Yes.
Okay. In the light of that, I am disposing of item number 4.
Yes.
WPC 3910 of 2025. Item 4. Please don't get confused. I am only referring to that annexure. So that is WPC 3910 of 2025. The Learned Counsel for the petitioner submits that. Prayer of the petitioner regarding treating qualification, quote, diploma in special education. Yes, Mr. Das, be attentive. Diploma in special education.
Yes, my lord.
Diploma in special education to be equivalent to diploma in education has been granted by the authorities by issuance of corrigendum dated 22nd January 2025, issued by the Odisha Subordinate Staff Selection Commission. Which paragraph you are referring? Corrigendums?
Maharaj, corrigendums, column number 3, as revised, part 2.
Who page re, sir?
Page number 50.
Page 50 is internal page 1 of 4. So corrigendum ro who page re?
Corrigendum no starting page.
Starting page. Who jaga re?
Maharaj, column.
Vertical column you are referring?
Column number 2 re. 2 years diploma, special education course with an NCT recognized 6 months.
Let me get it. 2-year diploma?
Special education.
Acha, which provides in the third column, quote, as revised. देखिए लिखी होता पर. The word DIET training is substituted. As under. It is up to document verification for journal. This is page 50 in item number 7. Para, in view of the above, nothing survives for adjudication. As far as prayer in the represented petition is concerned, the petition stands disposed of. କିଛି doubt ରହିଲା? କौन ପଚାରନ୍ତୁ? ଆପଣ page 50 ଟା ଯୋଉଟା ଲେଖିଲେ ଏଟା page 50 ସେଟା item 7 ରେ ଅଛି. ରେକର୍ଡ ଆପଣଙ୍କୁ ଦେଇ ହବନି ଆଜ୍ଞା. ଆପଣ 7 ଟା ନେଇଯିବେ item 4 ରେ. ଏବେ ଦେଖନ୍ତୁନି. ଟିକେ ଧୈର୍ଯ୍ୟ ଧରନ୍ତୁ. ଆପଣଙ୍କ ଯୋଉ ଖାତାରେ ଲେଖନ୍ତୁ item 7 list ରେ ଲେଖନ୍ତୁ page 50. Next.
Grateful, minutes.
Item 5.
You want 7 to be taken up now?
If the Honorable Court permits.
It is similar.
Malad,
So let us take 5 and 6. Yes. Let us go silly. 5.
Item 5.
Kindly speak to the mic. Adjust kar diyo. Tolu kar diyo. Aur bend it. Yes.
Ojalis matter. Self-sum is decided by division bench matter, sir. Division bench.
Your name, madam?
Manasi Panda.
Miss M. Panda. For the petitioner, Mr. Sanjeev Swai, AGA for the state. Learned Counsel for the petitioner submits that the matter arises out of Orissa Government Land Settlement Act and Rules, which is supposed to be assignment of
Division.
bench. It is to verify and do the needful for listing before the assigned bench.
Okay.
Yes.
Item 6.
Pass over.
7.
Please, Your Lordship.
Mr. S. Das, Saurabh Das for the petitioner, Mr. Sanjeev Swang AG for the state. Yes, Mr. Das.
Well, its advertisement was issued for the Sebika at the opposite party number 1 school. In that advertisement, diploma in elementary education was not included. As it was violative of the NCT rules and regulation, a corrigendum on dated 22/1/2025 was issued, through which diploma in elementary education is inserted. But now the reason to approach the Honorable Court is that we, the petitioner, possess diploma in elementary education of 18 months instead of 2 years. So that's the reason we have been embargoed, and it has been stated that we won't be given any appointment. Malas, it is actually.
So, what's the basis of you claiming that even if you are trained for 18 months or studied for 18 months?
Well, it's Honorable Apex Court has.
Kindly show that.
Indeed, Mallards. Mallards may peruse page number 76 of the writ application, Mallards. Paragraph number 12. This is a notice issued by NCT. If the Honorable Court permits, I would like to peruse the relevant paragraph.
So you find that decision in versus state of Uttarakhand. Have you annexed that?
Yes, Mallards.
Page?
Mallards, page number 78. Paragraph number 2 and 3. A review petition was filed, and in that review petition, it has been clarified.
78, paragraph 3.
Paragraph number 2 and 3. If the Honorable Court permits, I would like to peruse.
Kindly mark 3. Read 3 slowly, please.
However, to avoid any confusion, we again clarify that 18 months diploma obtained by such person who were
Stop there. It's a comma. Who were in employment as on 10/8/2017.
Yes, Mallards.
So,
Mallards,
how can that be a judgment in rem as far as future applications are concerned?
Mallards, we were employed prior to that date. We were employed prior to 10/8/2017.
It is your categorical statement that you are under employment. Show that in your petition where you have stated.
Mallards, appointment order is not been annexed of the Honorable Court.
No. I am asking you where in the writ petition you have stated that you are employed as on 10/8/2017.
Mallards, specifically we haven't mentioned, but
you see, Mr. Das, that clinches the issue. You are very well prepared, but the entire case hinges on that one sentence. You must.
If the Honorable Court permits, I'd like to submit an additional affidavit, Mallards.
No, it's not question of liking of the court or parting. Petitioner is free to approach a court. Petitioner is free to approach a court. Court has a corresponding duty. The language of Article 32? What is the language of Article 32?
Whenever violation of any fundamental.
I am not asking regarding moving. Tele Constitution. I am just taking your time to discuss something to encourage you.
No, Mallards,
you are so well prepared. Actually, you are prepared meticulously. I mean, the way one should prepare. What will be the discussion in the court? The right to move the Supreme Court by appropriate proceeding. It is applicable to any court. Right to move the court is a fundamental right also. So you don't require any liberty. But why it did not, strike you? Because that clinches the issue. The advantage would be that it would be a very, confined discussion, no prolonged deliberation, and they have to answer that. If they answer, it's fine. If they don't answer, then you succeed. Or you see, the state is not exactly an adversary. They will say that yes, you are engaged. By tomorrow, can you do the amendment? File the affidavit.
Let me give me 1 week of time. Actually, the petitioners are outside of Cuttack. They need time to travel. That's why. 1 week of time.
Suppose what is the prayer in the writ petition then? The last date is gone or it is there?
No, only the online applications form have been filled. No recruitment process has started. I've taken categorically instruction about that.
You have filled up the form?
Yes, Malad.
So, yes, Mr. Swai, I'm issuing notice.
The last date was on 31/1/2025.
He has filled up.
He has filled up the form.
He has stated.
Let it within 1 week, let him file an appeal.
Yes. So, today I'm issuing notice, or after 1 week you say?
I do lots of places, but
Okay.
company is required.
So, Mr. Hard Learned Counsel for the petitioner. ଆପଣ ବଜାଉଛନ୍ତି କଣ ତଳକୁ ଅନେଇ ବସିଲେ ମୁଁ କଣ ଜାଣିବି କେମିତି ଆପଣ କଣ କରୁଛନ୍ତି ଆପଣ ଟିକେ ଆଡେ ଘୁଞ୍ଚିଲେ ଆପଣ ଟିକେ ଆଡୁ ଘୁଞ୍ଚିକି ବସନ୍ତୁ so that I can see you what you are doing ଆଉ ଚେୟାରଟା ଘୁଞ୍ଚାନ୍ତୁ ଆପଣଙ୍କ ଆହୁରି ଘୁଞ୍ଚାନ୍ତୁ ଡାକି ତା ଚେୟାରଟା ଘୁଞ୍ଚେଇ ଦେଲେ ସେପଟେ କାହା ଲୋକକୁ ମତେ ରିପିଟ କରିବା ଦରକାର ନାହିଁ ଆପଣ ଯୋଉ ରହିଯାଉଛନ୍ତି ମୁଁ ଜାଣିପାରୁନି ଆପଣ ଲେଖୁଛନ୍ତି କି ନାହିଁ ଆପଣ ଗୋଟେ ତା ଭିତରେ ରହିଯାଉଛନ୍ତି ତଳକୁ ଅନେଇକି ଆପଣ ମୁଣ୍ଡଟା ଟିକେ ଉପରକୁ ଅନେଇକି ମତେ ଅନେଇଲେ ମୁଁ ଜାଣିପାରିବି ଯେ ଆପଣ ଲେଖୁଛନ୍ତି ବୋଲି you have some difficulty in writing shorthand what I can do ମୁଁ ତ ଆପଣ ଚେଷ୍ଟା କରୁଛି ସାହାଯ୍ୟ କରିବା ପାଇଁ High Court Counsel for the petition it is submitted that the petitioners are applicants for the post of
Sebaka Sebika at
Sebaka in
opposite party number 1 schools.
Opposite party number 1 schools. Pursuant to the advertisement issued by the Odisha Subordinate Staff Selection Commission into bracket OP number 2. They have applied the last date of filling up of forms being 31st January. Yes. 31st January 2025. It is submitted that a corrigendum has been issued enclosed to the writ petition marked as Annex 3, dated 22nd January 2025, which has provided for the ability towards educational qualification to be 2 year. को जार शेड़ा देखो थिले?
मतलब 2 years कोठी लिखा है नहीं खाली लिखा है diploma in elementary education.
कोई सेंटेंस ता कोठी सल्ला पढन्तु diploma in
elementary education
तापर लिखन्तु ब्रैकेट रे D capital dot EL all capital all caps dot E capital D small bracket closed DLED. See page 50 देखी लिख परिबे. Don't make mistake. How do you say that they will be rejecting your qualification because it is 18 months?
I'm coming to that because DLED is generally of 2 years. Now, as the teachers who were appointed way back were not able to fulfill the educational qualification, NCT as well as...
That's not the question. You can't be defensive and presume that. You see, after this Vishwanathan Matt case, there is no specification that it should be 18 months or 2 years. So why, how the court will know also?
The reason
is so that from your pleadings or any annexer. You end up working up the sleeping dogs.
Paragraph number 8, Millets, of the writ application. If the Honorable Court permits.
I mean, what is the event that creates such apprehension in your mind, petitioner's mind?
After the online application, as it is a general practice going on in every recruitment process that DLED of 18 months are not given an opportunity. After that, petitioner went and
you have to challenge that condition if it is there. Court cannot add to the condition, the advertisement condition or the advertisement that you should accept 18 months or 2 months because that occasion has not come.
No,
the question is very specific, Mr. Das.
It has been articulated to us, my lords, that
Who has articulated?
opposite party number 2. We went to the office.
Where?
My lords,
Where?
it has been
Can
articulated.
it be done in a court process?
My lords may issue notice if the
No.
our pleading is detrimental or dichotomous. They may file a reply to that.
You see, your apprehensions are not supposed to be, judicially scrutinized.
My lords, we aren't apprehending.
Never. So you see, I have been repeatedly asking you, please show which condition. First of all, since you refer to the corrigendum,
Yes, my lords.
that is how I inferred that corrigendum provides that it is 2 years. When I asked you, you show me in page 50 or any part of the corrigendum of 4 pages, where it shows that it has to be 2 years, you say, no, there is no specification.
My lords,
That is your clear stand. That is what you have stated. You can see the replay even. Then I ask you that then how you are apprehensive that they will reject your application for 18 months diploma. Then you struggle to answer that there is nothing. It is simply a general statement. In so many recruitments, it has happened.
OP2 has
So
only
we have gone and inquired in the office.
My lords, the reason is
Where you have stated that you have gone and inquired in the office from whom? Have you made him a party?
yes, opposite party number 2, my lords. Opposite
OP
party
number 2
is the recruiting agency. We went.
Not the agency is a inanimate object. Which individual has talked with you? There can be RTA application. RTA application helps here. Suppose you ask a RTA that whether 18 months diploma is equivalent or gives us eligibility. They may say that 18 months diploma is not. There is nothing like that. It is a speculative writ petition or apprehensive writ petition.
It will be
Writ petition based on apprehension.
Can I make a small submission by being
No,
very
you
fair?
make all big submissions. Why should you confine to small submissions? Carry on. Don't get.
But in that case, as the Honorable Court is not sure that.
No. You are confused. The court cannot be. I can't inquire and be sure of it. You must appreciate the petitioner has to be sure of the grievance.
In that.
I'm not here. That's the job of a lawyer. Is there anything on record to show that they are not honoring 18 months?
In that case, Annexure 10 may be considered in the light of Annexure number 7.
Annexure 10, you don't require any lighting as far as recruitment is concerned. Because you see, your apprehensive lighting is not required. Because that creates a very difficult situation. The court is not a matter of this kind of venturing into anything and everything. When you are coming to court, you are not sure what is your grievance. Repeatedly, we have already spent around 15 minutes to know what is your grievance.
In this case, the issue will be there. If we wait tomorrow, if they do not select us, in that case, the number of posts, if they are filled up, then we will be left with no.
Sir, that is also apprehension. There are thousands of cases pending here where after they are not selected, that gives to a cause of action and petitioner's approach. There can't be a preemptive writ, Mr. Das. Which writ can be preemptive? Which, according to you, can be preemptively issued?
I was reading yesterday on this slide. Whenever there is a threat to Article 21, detention is there and detention order is illegal, or the action of the
preemptive writ, sir. Preemptive to preempt that not commit an illegality. If that is possible, all the courts will also close down. There has to be a cause of action. You do not have any cause of action.
Then I pray that
you see, in fact, I told you that don't wake up sleeping ducks also. Till you are not sure whether they will entertain 18. You are just imagining things.
The
Subordinate Staff Selection Commission will reject our application. Then so that yes, it is a qualification. You see, the thing is that suppose it is advertised. Think in a broader matter. Suppose it is advertised that only 2 years diploma candidates can apply. Then you have a definite case. In fact, that was my understanding when you started submitting. Yes, Mr. Swain. Don't oppose him. You try to assist him.
Actually, in the meantime of development, it must have been done up. The 31st was the last date. In the meantime, 3 months has already gone. So what is the latest position? Unless know that.
Mr. Swain, that is how I am thinking that their candidature has not been rejected.
No, not rejected. So it is apprehending that it might be rejected.
And for basis is not there also.
So,
Well, it's page number
Because that
66.
corrigendum doesn't specify it is 2 months or 2
only
years or 18
apprehension,
months.
only he is apprehending. Till today, he is not aware of.
Well, it's basis at page number 66.
What can be done?
I cannot also take instruction because it is.
Yes, you cannot. You cannot.
Well, let me peruse page number 66. NCT's regulations suggest diploma in elementary education is up 2 years.
Sir, that is not relevant. Sir, that would, if they are trying to defend it, suppose, let us assume that they fix the period of training to be 2 years. Then that will be, so why you are entering into that area? Till now, you are yet to be declared. Your application is declared to be ineligible. Your application is yet to be rejected. You are simply apprehending something and without any basis also. Suppose there is a eligibility condition which prescribes that the diploma shall be of 2 years.
It is there at page number 66 of the writ application. If the honorable.
No, advertisement, sir. कितने थरो आपन गोटे जिंस कहया को पड़िबो. Where the advertisement shows that it is for 2 years. So then why you are going behind the reading between lines, adding something? Yes. It is submitted by the Learned Counsel for the petitioner that the advertisement doesn't refer to the period of training, public education, for obtaining such diploma. When you are going and discussing entering the office of the Odisha Subordinate Staff Selection Commission, discussing with people, secretary apan कहले एटा.
मतलब secretary no.
तल काई आपण तांको आणुचंदी कहउचन जे तांको करछि से कहले.
ना जिनसो होछि तांकर गोटे executive order थिलो grievance management रे.
Don't do these things. Leave these kind of these are all there is not for a lawyer.
मतलब secretary
very particular. Oblique कौन लिखले? कहीं भूल पड़छन. The 6 accommodation to obtain specific instruction regarding the cause of action, if any, for the petitioners to be apprehensive that application shall be rejected. Instruction. Regarding the reasons, if any, the petitioner's candidature shall not be considered. How much time?
Well, let's RTR में document आने की withdraw with liberty. For now, we will apply for RTR.
नहीं, withdraw करो. Take your time. Take your time. Contemplate. Withdraw कहीं कर देवे. Withdraw is the last thing you will do. You may be right. You should not have, triggered this thing. By whole process, you are triggering a situation where they do not say that it is 18 months. You are saying that it is 18 months and 2 years are different. Now, yes, you are right. That I was not telling you. Well, when I was telling you that you are waking up sleeping ducks, they don't impose such a condition. You, on a self-imaginary situation, you are saying that they will impose this condition. You are raising a controversy. Mr. Das, by filing a petition, you are raising a controversy. So you take time, let it come tomorrow. You make up your mind. After instruction, list tomorrow. You contemplate in a cool mind. Don't be in a hurry to withdraw a petition, because hurry means you are withdrawing means it will be res judicata. Please appreciate that also. And whenever you are receiving some instruction from a client, be particular. You are saying that we went to the office, they told. Now you are saying I do not know who told. No, if you are serious, then let them file affidavit. You have to compel them to file, ask them to file the affidavit so that at least the person will answer. Don't be speculative in these things. Please tomorrow.
Grateful, man.
Item 8.
Your item 7 is similar to item 4, Mr. Das. It's not different. Item 8 takes care of everything. They don't distinguish between any kind of diploma, 18 years or 2 years. It is not there. A matter little bit very similar, but 2 year or 1 year was decided by the division bench recently in other matter. Anyway, item 8,
Great.
Mr. Dr. S. Ranjit.
Yes, my lord.
Dr. S. Ranjit for petitioner. Mr. Sanjeev Swai, AGA for the state. ଆପଣ adjournment କରି ଲେଖିଦେଲେ ତ? Mr. Barik. Yes.
My lord.
Yes.
Yeah, the petitioner is the trained graduate teachers.
No, what is your prayer, sir?
The prayer is to disposal of direction for disposal of the representation pending before the OP number 4, my lord.
You are sure that disposal of representation will not lead to further litigation?
My lord.
And
If
the
the region
petitioner's
order is
prayer,
passed,
petitioner will achieve his remedy?
Yes, my lord. If they don't pass the region order, then they have the liberty to come back again, my lord. Because 2011 onwards,
Let them take instruction.
My lord.
At least today we have 2 cases where after disposal of representation, nothing has happened.
Yes, my lord.
Because
I will be grateful.
You are agreed by what?
Pardon, my lord?
You are agreed by what?
Not allowing me to continue in service, my lord.
By which order?
In 2011.
By which order?
By
you are agreed by you are agreed by not allowing you to continue in service. By which order?
By the order, and I have annexed your lordship.
Then please, Mr. Ranjit, you are PhD in law.
No, humanities and social sciences.
You must bring the basic document on record.
I have brought in my law court.
Oh, you are saying I have not annexed?
14.
You are saying I have not annexed?
I have annexed in Annexure 14.
So you should not say that I have not annexed. You should say that straight away.
Probably.
Acha, I'm sorry. I'm sorry then.
Page number 43. When they did not allow to work, my lord, then I approached the tribunal, education director, they passed the order. And the single point what happened was that I was not given the appointment letter. And then I came.
So this matter will lie before the tribunal then?
Yeah. After that, your lordship, I approached before this honorable court. And this honorable court, I have annexed the order, Annexure 15.
Page, kindly refer to the page.
Number 46.
Yes.
And the order is for page number 49.
Yes.
This honorable court was pleased to direct me to approach again for the appointment letter and dismissed withdrawn, my lord. They gave me the liberty to go back again I approached with the Annexure 16 for which I have come for the direction to disposal expeditiously. There I filed with this order along with the annexures.
After 5/11/24, you have approached by which petition? Show the page. Pursuant to, there is a direction to you by the High Court, or you told the High Court that I will move the authority.
Yes,
by which application you have moved? Come to the page.
I have moved Annexure 16, my lord. That is the application.
Then what happened, sir?
Thereafter, that has been pending. They are not deciding on that. It's pending since.
Then why you are saying that again you will file a representation?
Already I have filed. So
please. Yes, Mr. Swai, you obtained instruction.
My lord, it's a matter again pending with the headmaster of the school.
Is the managing
secretary management?
Notice to go, you are saying.
Notice.
You will not appear.
My lord.
The learned counsel for the petitioner. Appearance lekhantu. अरे आउरी भी अच्छे आज्ञा कौन खाली स्टेट सबुतरे पार्टी आउ के हेबेनी कौन आज्ञा आपण अपोजिशन एजीए फॉर ओपी नंबर 1, 2 and 3
our against is grievance 9.
Correct. I got it. When you said that, 1, 2 and 3. No, my secretary says that you will appear for everyone. So that is how I have to explain him.
Yeah.
The petitioner is agreed by the authority not disposing his application. Say authority party karchanti, Mr. Dr. Ranjit?
Yes, my lord. OP number 5.
Authority OP number 5. ताका नाटा तापर description टा लिखिए OP 5. So and
managing Vivekananda High School.
Not disposing the application of the petitioner dated 18/11/2024, which was filed pursuant to the order of this court, WPC order of this court passed by the coordinate bench dated 5/11/2024 in WPC number 26589 of 2024.
My lord.
wherein the petitioner withdrew the writ petition to approach the authority. The petitioner alleges inaction on part of the authority. DGA appears upon advance copy served for the opposite parties 1, 2 and 3. No, sorry, 1 TO2 4. Likhile 1 TO2 4. He submits that no cause of action as far as the opposite parties 1 to 4 are concerned because the petitioner has represented the OP number 5. Issue notice along with this order. Requisites for issuance of notice to OP number 5 by registered / speed post be filed within how much time?
3 days, ma'am.
Within 3 working days? Within 5 kar diyantu.
5.
Within 5 working days, fixing early returnable date. List after speed post nebe?
Speed post.
Achi seti speed post?
Achi, sir.
Biri court re achi?
Achi, sir.
List after 3 weeks. Liberty to mention for listing before the assigned bench. Yes.
Obliged to lodge.
Please call the list, Mr. Barry.
Item 9.
Mr. P.K. Parida on behalf of A for the petitioner, Mr. Sanjeev Swai, AGA for the state. Adjournment is sought for on behalf of the Learned Counsel for the petitioner. Due to personal difficulty, aspirate for list after 2 weeks. Liberty to mention for listing before the assigned bench.
Item 10.
Item 10, your matter, Mr. Swai. Mr. Swai, state is the petitioner.
So, may it be taken up next.
My pardon. I am appearing from opposite party number 1.
Caveat karchandi?
I am a conducting advocate of the trial court, my lord.
Best to wait. To upon aji jindi mark kole mark karo to mu jodi upon jodi dismiss ହେଇଯିବ ରିଟ୍ ଆପଣ ଫିଜ୍ ପାଇବେ କିଛି ଅସୁବିଧା ନାହିଁ ସେଦିନ
ଗୋଟେ କପି ଦେବି ସାର୍
ସେଇଟା ଆପଣଙ୍କର କୋର୍ଟର କ୍ଷମତା ନାହିଁ ଯାହାକୁ ଯୋଉଠି ଫାଇଲ ସେଟା ହାଇକୋର୍ଟ ରୁଲ୍ସ ରେ ନାହିଁ ଯେ ଯୋଉଠି ଷ୍ଟେଟ ଫାଇଲ କରିବ ସମସ୍ତଙ୍କୁ କପି the rule is otherwise whenever you are so there no difficulty there is no rule in the high court rules to direct that whoever has challenging the tribunal or trial court order state should serve copy ଯେମିତି କିଛି ନାହିଁ specific be particular that's the beauty of the profession ଆପଣ ଆଜି ଯେମିତି ୱାଚ୍ କରୁଥିଲେ ୱାଚ୍ କରିବେ let us see the learned Sanjeev Swai AGA for the petitioner hybrid mode likhibe dekhantu the learned counsel the learned AGA submits that he may be accommodated to advance arguments. How much time, Mr. Swai?
Next week.
List next week.
Item 11.
S. Naik for the petitioner. Sanjeev Swai, Mr. Devraj Mahanti, the learned counsel for the petitioner, 6 accommodation. List, आज prayed for list day after tomorrow.
Well, may I please, your lordship.
Mr. A.K. Sahu.
Yes, please.
Mr. A.K. Sahu for the petitioner. Mr. Devraj Mahanti, AGA for the state. Yes, Mr. Sahu.
My lord, the present petitioners are agreed the order dated annexure 1 running page, your lordship.
This order is not applicable before the Board of Revenue or revisable.
It was the order passed by the RDC North Division, Hon'Ble, your lordship, under section 15B. Orissa Survey and Settlement Act.
Your submission is that it is not applicable.
It is not applicable because only one opposite party is appeared in that court, your lordship. Another 10 opposite.
No, I am not asking how many parties have appeared.
The question is very simple.
Yes, Lordship.
Whether if it is appellable order, go for appeal. If it is not appellable, the writ is the remedy.
My
So
lord,
that I am asking.
my lord, it is the
the number of parties are not relevant there.
Yes, sir.
Anyone can approach the writ court. Whether there is a more efficacious remedy of appeal here or not, that's the question to you.
Your Lordship, this is the final authority regarding surveillance settlement. 51 years old matter.
Not appellable.
Not.
15B. In fact, he mentioned 15B, but then he's changed the...
Yes, Your Lordship. Because
petitioner, yes. So how you are agreed by the order?
Because the order is that my father has sold the area Ekersun 14 decimal.
Which paragraph?
Yes, Your Lordship. The sale deed.
Which paragraph of the order, not sale deed, sir?
My lord, in
which
order.
Which pending on merit?
Yes, sir. Lastly, Your Lordship.
Page ta tige kontu?
Page 25, Your Lordship. Page 25.
25.
Yes, Your Lordship. The entire pronouncement of the order. Tahsildar Bhuban is direct for Tahsildar Bhuban is, it is wrongly written Bhubanis, but it is Bhuban. Directed to implement the order as per my above observation.
Let's see the paragraph 4 of the page 20. That is the finding.
The hall plot number 571 and the hall area Khatan 169, unit 5, Tolongbereni, etc. So, my lord, have a glance of my sale deed, Your Lord.
You are OP7?
No, my lord. OP is, I am all other opposite parties. I am not OP7.
Before the RDC, you are arrayed as OP number?
I am not appeared in the RDC.
Not appeared, but notice was issued.
I am not appeared. I am OP7 is here opposite party, Your Lordship.
Sir, I am talking about the proceeding before the RDC. So that I am asking you repeat. Twice I have asked you, sir. What was your status before the original this authority? ଆପଣ କଣ petitioner ଥିଲେ, opposite party ଥିଲେ, କଣ ଥିଲେ ଆପଣ?
ଆମେ opposite party ଥିଲୁ ସମସ୍ତେ. କେବଳ 7
ସେ petition copy କାଇଁ?
Yes, Your Lordship.
କାଇଁ ସେ petition?
That was on the page.
Page କୁହନ୍ତୁ.
26, Your Lordship. One Bhagavan Guru is appeared.
अरे आपण कौन कहउछन्ती मु पिटिशन टा देखांतु बोली कहउछु वन भगवान
26 running page 26, Your Lordship.
पिटिशन कॉपी
आज्ञा सी जो देइजंती तांकर येटा टोटली तांकर
आपण एतरे की
आमे all other opposite party, Your Lordship.
अरे all other नो आया you are all are in the writ petitioner Narayan Guru to Kamala Pothal. All have approached this court?
No, only 5 approached Narayan Guru, Jayadev Guru, Ketaki Patra, as well as the Sarya Guru, Kuntala Guru, and Kamala Bihari is appeared. And another reason.
Narayan Guru hele.
Yes, Your Lordship.
Jayadev hele 8.
Yes, Your Lordship.
Ketaki is 10.
Yes, Your Lordship.
3 jana to thile.
Sarya Guru. Sarya Guru, Your Lordship.
Sarya Guru.
6.
Then Your Lordship, Kuntala Prushti alias Guru.
एते समय कोन लागु छै आपण मु पचारि जे आपण तो कहिबे दैट वी वर अपोजिट पार्टीज आपण को जणे कहले तापरे कहले रिपिटिशन ने 7 कहले 7
तांकर जो से रिवीजन टा करथिल
जस्ट लुक एट योर ब्रीफ आपण 11 जण अछंती अपोजिट पार्टी तो 7 कहउचंती
आमे 7 जण 6 जण आमे आसीचु 7 खाली
सर नोबडी इज डिस्प्यूटिंग बट यू आर नॉट आंसरिंग
पार्डन
A.K. Sahoo for the petitioner, Mr. Devaraj Manti, AGA for the state. Hard learned counsel for the petitioner. The petitioners were the opposite parties in the proceeding in RP case number 234 of 2024
under section 15 into bracket small b of the OS and S Act, 1958. Full form लिखते हुए at least थोड़े. Survey and Settlement Act 1958, initiated by the
DC North Division, Sambalpur.
Initiated by the present which opposite party that I'm trying to record.
Yes. Pardon.
Filed by the petition.
Radharani. One Radharani. OP number 5.
Initiated by the OP number 5 in the writ petition, being the petitioner in the RP case. It is submitted that the order passed by the authority suffers from non-consideration of material on record, also wrong appreciation of law. Issue notice as above. Learned AGA upon advance copy served appears on behalf of the opposite parties. 1 TO 2 waives notice. Notice to opposite parties number 5 to 10 by speed oblique registered post with AD, fixing early returnable date, be filed within how much time?
Yes, let's see, 5 working days.
Within 5 working days. List after SR, liberty to mention for listing before the assigned bench. Yes.
30 in your lordship, as per interim measure, your lordship,
So far as the interim order is concerned, all the materials have been considered because he has
status quo. Because his petition his petition is status quo as on date, because his petition will be rendered infructuous. I mean, for adjudication there has to be something also. IA 2423 of 2025. IA 2423 of 2025. Issue hard learned counsel for the petitioner, issue notice as above, along with the writ petition. The learned AGA appears on upon advance copy served on behalf of the same Royla. Complete repeat. Requisites for issuance to notice to the opposite parties 5 to 10. Registered with speed post be filed within 5 working days, accept one set of process fee as well as postal requisites. Ekati ojon kori ki dei debe. I am given to understand that it is acceptable. Jaha rate jaha hobo dite jaga missei ki postal requisite dei debe.
4 weeks.
List after SR. As an measure, it is directed that status quo as on date regarding the nature, character, ownership, possession of the property described as dekhantu sir.
Yes, sir.
Co-paragraph. Three dekhantu page 5, page 3, 5 dekhantu. Paragraph 3, page 5. Area 0 acres 0.14 decimal.
Yes, sir.
Acres 0 देखिए लिखिए 14 decimal corresponding to Sabaka plot number dash Mauja dash out of
4 aberment 4 your lordship page 5 4 your lordship. It is hall settlement.
ठीक है कौन लिख ले description out of total area acre 0.20 referred to in registered cell deed. अपन ये जो सेल डीड चाहूँचंती तो don't get confused Sahoo, don't get confused आपण confused हेले कोर्ट को confuse कर दोचन
हजुर सेटा साबक रे हितला एबे
सेटा बुझिली सर
आगे हाल एरिया टा
मु आपण को हाल सबक पचारची की मु कहली टिके रुहंतु कहली मु पचारली जे द एरिया रेफर्ड टू इन द सेल डीड आपण चाहूँचंती तो स्टेटस को
4 आई एम करंट आवर
टिके रुहंतु आपण जो एरिया टा रेफर हेची सेल डीड रे सेटा चाहूँचंती स्टेटस को तो
सेही सेल डीड टा करेस्पोंड हो जाईची
हाल अपेक्षा करंतु मु तो कंप्लीट करता आपण मते इंटरजेक्ट बारंबार करचंती करी दो नांती कोन लिखले 20 decimal are referred as referred to in cell deed number 781 of सेठी आपण ऑर्डर बंद करी देले और cell deed number 781 of 781 dated 22.03.1973 into bracket annexure 2 corresponding to the HAL settlement published on 24/1/1983 मौजा यूनिट 5 पूरा डिटेल टा लिखिबे पारा 4 रे अछि डॉट एकर 0.105 decimal. Now you are satisfied Mr. Sahoo?
Obliged. Plot number
but आपण से सेल डीड पाखरे आपण अटकी की रहले आ मते because there has to be a reference, so I am referring to the cell deed.
No,
you see discussion is never negative in a court.
Pardon your lordship. Has no right title interest because their father
let it be the status quo.
Pardon.
But Mr. Sahoo, you are maintaining status quo. That is you must understand. You are not out of it.
No, your
please
lordship.
appreciate.
No, your lordship.
For status quo be maintained by the petitioner as well as the opposite parties.
Both the parties?
All. No individual say, then that I don't know, my father had filed a petition. When I was asking you who was the petitioner there, who is the opposite party here, that is the purpose. To understand the chain of this litigants. Shall be maintained till disposal of the writ petition. Yes.
Pardon.
My lord, Mr. Bahali is out of station, my lord, due to some urgent medical work, my lord.
What करनांदी?
My lord,
appellable order.
After 2 weeks.
Mr. R.K. Sahoo, you have power, Mr. Sahoo?
Yes, my lord.
आपनकर कोन कुडी हे जाईची सेठी पण एमती कोन देखा जाउछन? Light पड़ी जाईची. तो R.K. Sahoo for the petitioner, Mr. Devaraj Mahanti AGA for the state. Learned counsel for the petitioner appears through VC and submits that he may be accommodated in absence of the arguing counsel. How much time, Mr. Sahoo?
My lord, let it come after 2 weeks.
List after 2 weeks as paid for liberty to mention for listing before the assigned bench. Ms. Mahapatra, S. Mahapatra, Sashwati Mahapatra for the petitioner, Mr. Devaraj Mahanti, AGA for the state. Yes, Ms. Mahapatra.
Well, this is the matter. Your lordship find that there is rejection of mutation case and that is under page 21, my lord.
Not appellable.
It is, my lord, that's the case I'm saying. 31/10/2020.
Yes.
This has been rejected.
Yes. But by limitation, the limitation is 60 days. Or 30 days.
60 days, my lord.
Mutation appeal?
Well, there are just
Survey Settlement Act.
Just one thing I want to draw your lordship's attention. Page 20.
So I will condone the delay. Will approach the mutation appeal.
Appellate authority. Or your lordship.
Provision da to kahibe na provision mat dekhiya padibo. I will assist you. Kuhuntu state let us speed up.
I have not come for this appeal, my lord. What I have come praying before your lordship is maybe remanded for the Tahsildar because in one case, page 23, by virtue of this order.
You see, Mrs. Mahapatra, even remand also that prayer can be made in the appellate court. In most of the appellate orders, you will see the sub-collector sitting in appeal remands the matter for reappraisal of facts. So then I have to issue notice. And the matter will be kept pending here, adding to the pendency. Petitioner doesn't get anything.
That's the notice, my lord, your lordship can.
So this remand should have been made by the appellate
That
authority.
is a similar order, my lord, by this honorable court recently.
No, similar order is not a binding precedent because it is an order. So leave. I don't even require any order for entertaining a matter. Why should I? It's a fresh matter. So let us not concentrate on that. Let us concentrate on your case today. Let us not concentrate on what has happened in some other case.
Yes, lordship, everything I
No. You see, when you are saying I know everything, the repeated argument is that I don't have roster. So both are opposite ends. So ଆପଣ ଚାହୁଁଛନ୍ତି କୁହନ୍ତୁ ଏଟାକୁ ସେ କଣ୍ଡୋନ କରିଦେବି ଡିଲେଟାକୁ
କରିକି appellate authority ପାଖକୁ
ହଁ ପ୍ରୋଭିଜନ ଟା କହିବେନି ବହି ଆଚ୍ଛା ବହି ନାହିଁ ଠିକ ଅଛି
ଏଟା ହଠାତ୍ ଆପଣଙ୍କ ପାଖେ ଆସିଗଲା ମୁଁ ଆଉ ବହିଟା କେତେ କହୁଛି ପାରା
92 mutation manual and
100 କେତେ 92
92 para 92.
Rule 42
para
କିଛି ଏକ୍ସପ୍ଲେନ୍ କରିଛନ୍ତି କାହିଁ ଡିଲେ ହେଲା ଆପଣ ଏନି ଏକ୍ସପ୍ଲାନେସନ ବାହାର ରହୁଛନ୍ତି hard appearance like this hard lawyer counsel for the petitioner. The petitioner is agreed by the order ta jota apanakar impugned order
31/10/21
by order dated 31/10/2021 page ta kon miluni mate
page 21 मैंने
अच्छा
last line खाली गोटे लिखा है जा रहा है
ओ आपनकर order dated 31/10/2021 passed by the opposite party number dash Tahsildar Pipili in mutation case number ta koti milibo mutation case number 976 of 2019 annex 3 dekhi likhi paribe it is submitted that the errors the order suffers from non consideration of material on record as well as the propositions of law. By rejection of the mutation application, the petitioner has lost his valuable right to property and is aggrieved. It is further submitted that the petitioner staying outside was not aware of such order. Upon service से ground challenge है जो order टा
ଆପଣ ରିମାଣ୍ଡ କରୁଛନ୍ତି ଅପିଲ କିଏ ଯିବ ଚ୍ୟାଲେଞ୍ଜ କରିବାକୁ
କଇ କରୁ ନାହାନ୍ତି ତ ବହୁତ ଭଲ ଆପଣ ଅଭୟ ବାଣୀ ଦେଇଦେଲେ ଆପଣ ଠିକ ଅଛି କାରଣ ମୁଁ ସବୁ ଆପଣ ତ କିଛି ଗ୍ରାଉଣ୍ଡ କହିଲେନି ମୁଁ ଗ୍ରାଉଣ୍ଡ ନିଜେ ଲେଖୁଛି ଗ୍ରାଉଣ୍ଡ ତ ଆପଣ ପଚାରିଲେ କଣ ଗ୍ରାଉଣ୍ଡ କହୁଛନ୍ତି ଡିଲର ଆପଣ କହିଲେ ବାହାର ରହୁଛନ୍ତି
that is a lordship's greatness that is lordship
କଣ ଗ୍ରେଟନେସ୍ ଆଜ୍ଞା
I am doing
ଆପଣ କହିଲେ ବାହାର ରହୁଛନ୍ତି ମୁଁ ରେକର୍ଡ କରି ଆପଣ ପଚାରିଲି ଆଜ୍ଞା ସେଟା ଭୁଲ ହବନି ତ
100 cases per day I am doing only one case
ସେଗୁଡା କଣ ମିଳିବ କଣ ଲେଖିଲେ petitioner stays ମାନେ ସେ ବାହାରେ ରହୁଛନ୍ତି stays outside at his workplace କଣ ଚାକିରି ବାକିରି କରୁଛନ୍ତି ନା କଣ
ସ୍ତ୍ରୀ ବୋଧେ
ଦିନ ମଜୁରିଆ ନା କଣ ଦିନ ମଜୁରିଆ ତ ଆପଣ ଏନଗେଜ
ଦିନ ମଜୁରିଆ ନୁହେଁ କାରଣ ଜାଗା କିଣିଛି ଦିନ ମଜୁରିଆ କେମିତି ହବ
The petitioner staying outside is not aware of such order. The matter may be remanded to the petitioner be directed to move the appellate authority and the delay in approaching the authorities be condoned. The Learned AG in response submits that the petitioner has approached the writ court much after passing of the order by the Tahsildar. It is not disputed at the bar. However, it is agreed at the bar that the order is applicable under the Odisha Survey and Settlement Rules, 1962, Rule 42. Which provides for appeal against the order of mutation passed under Rule 41. Having had learned counsel for the Lord petitioner, the Lord AGA, considering the fact that the petitioner's right to property is at stake, taking a sympathetic and pragmatic view, it is directed that how much time, Mr. Mahapatra?
Also direct within 2 months.
Ette din niyontu
Oh,
ni.
1 month.
Apano
4 weeks.
apano 4 years delay, sir, madam. 4 years delay.
As your lordship pleases, my
ठीक
lord.
अछि.
Your lordship is giving.
So, no, the order, it doesn't look, proportionate. Somebody approaching after 4 years, we grant further 8 weeks.
That's why this is High Court, my lord. This is
Directed
the
that
highness of the High Court.
as undertaken, if the petitioner shall approach the appellate authority by filing
Appeal.
appeal within a period of 4 weeks, the authority shall consider the same in accordance with the OSS Act and rules read with the mutation manual, condoning the delay in approaching the authority. Failure on part of the petitioner to approach the authority in appeal shall result in the order dated 31/10/2021 to be followed with the consequences. Yesterday I have found out this language. No, not punishment. 6 weeks कर दियंतु. आपण जहा कने 6 weeks आपण को नले हबनी आपण छाडीबेन नले. ठीक है 6 weeks दे दियंतु. नहीं, you see the 6 weeks दे दियंतु. ठीक है. It is clarified that this court has not expressed any opinion regarding on the merits of the case in any manner whatsoever. Yes. Mr. Kora for the petitioner. Mr. S. Kora for the petitioner. Mr. Devraj Mahanti, AGA for the state. Yes, Mr. Kora. Just kindly speak to the microphone. Yes, please.
But Annexure 4 is the impugned order, Your Lordship.
Annexure 4.
Annexure 4 at page number 20.
What is the prayer to set aside Annexure 4?
Yes, madam.
It's not applicable.
But this is an order passed under an application.
Regulation 2 of
15B.
15 or B?
15B. B.
15B, collector has power.
Yes, madam, that is one of the grounds. Second is, madam, this order has been passed against a dead person.
And that is written as Office of Collector com revisional authority.
The revisional authority cannot
power may be vested,
cases it can be revisional authority, but in under Survey and Settlement Act, the member board of revenue has the authority, madam.
Power may be vested to, I don't know. But
the lack of jurisdiction, Mr. Mahanti, it's a lack of jurisdiction.
Yes, lack of jurisdiction, collector has no power as per the OSS Act. But it is.
Please mark that dekha jauni. If you look at page 20, it is hazy ହେଇଯାଇଛି.
No, 22 ta dekhandu.
Yes, kindly mark 20. The opening line. That is hazy in your brief. My brief, I have the advantage of enlarging it.
15B of OSS Act.
Yes. So he has no power. So he is conscious.
Absolutely no power. But your lordship see that page 24.
So you take instruction or I'll remand it? You take instruction.
This order has been passed more particularly against a dead person.
Against a dead person.
Against a dead person. It has been observed. Your lordship may kindly turn to page number 23.
So far as power is concerned, they have written that collector and revisional authority. So that
15B, how can he assume power?
The government may be given a.
So you check it. I don't think ever I have seen any notification.
Obviously
because it is not required. It can be additional commissioner.
Yes.
15B power is also given to additional commissioners. There are so many additional commissioners passing order day in, day out.
It's.
I don't know. He might have been notified. We do not know as of now.
But
more hard learned counsel for the petitioner. It is submitted that the petitioner is agreed by the order dated 18th June 2024. Case 20 rachi. In case number 121 of 2024, passed by the collector. Nuapada.
Collector com revisional authority.
That I will not write. If I write, I will quote it within quotation mark.
18 July. 18.7.
Notified.
Mm-hmm.
Sir, my learned friend said that it is a notified.
Notified.
15B power. So that's why I'm saying that.
But he was seeking mandamus against a computer actually. That date, you have to remember. 18/7/2024.
That is there. Therefore, I have
So
said
that point goes, Mr. Kora.
Yes, then my this
Date
authorized
person, date person. Okay. So that
Date
has to be
person.
factually, it has to be verified.
But I have filed one death certificate it is at Annex.
No. You see, I am not the authority. They have to verify whether the authority had this death certificate or not. Appeal is a continuation of proceeding, fine. But factually, suppose then my observation would be wrong, Mr. Kora.
If you lordship turns.
No.
Annexer
Suppose the authority has no occasion to know that,
yes,
then the High Court observing that the authority has order against that person is a problem. Rather, High Court should say that authority has passed the order, but later it has come to the notice that the person is no more. That is another thing.
Simply, your lordship said that I will take instruction.
Yes. What likely?
Private opportunity.
The Learned Counsel submits that the power has been exercised under the section 15B of the OSS Act 1958. 15 into bracket small b. Orissa Survey Settlement Act 58. There is the authority of the collector acting as the revisional authority has not been mentioned in the order, or it has been mentioned because I had changed his submission. Not mentioned in the order. It is further submitted that the opposite party, number one, before the collector had passed away since date tak huntu. Since
20 June
2007, much before the matter was taken up on 18/6/2024.
18.7.
Look at page 20. You have to be on your toes.
I beg.
And there is a possibility after it was initiated, he passed away. Then he was not substituted. Please understand the tenor of the order also.
I beg pardon.
Please. No, I'm only trying to encourage you. Yes. Then sentence ta padhantu. Sentence ta par padela kon कहली भूली गली. June 7. The sentence is the much before the matter was taken up on 18 June 2024. 18/6/2024. July no. 18 first order to. So then he had passed away by then.
Yes.
So it is an order passed against a dead person.
Yes.
The learned AG seeks accommodation to obtain instruction as prayed for. List after
4 weeks.
List after 4 weeks. Now, after he obtains instruction, the matter has to be remanded to the collector because if he is notified, he will obtain that instruction. The learned AG seeks accommodation to obtain specific instruction. Instruction list after as prayed for list after 4 weeks. The learned AG shall obtain specific instruction in response to the contentions raised by the learned counsel for the petitioner.
Grateful.
Liberty to mention for listing before the assigned.
But there is a IA. I have filed IA number 2677 of 2025. But the present opposite party.
Issue notice anybody.
Issue notice करो.
Issue notice करे पड़े.
No, it is trying to alienate the property. The lordship may direct.
Issue notice as above. Issue notice as above. Along with this order. The learned AGA, upon advance copy served, gives notice on behalf of the opposite parties 1, 2, and 3. Proforma party को notice नेबे?
Proforma माने भाई भौणी होचंती.
नहीं, are they contesting or you will only take to OP4?
OP4 only.
The learned counsel for the petitioner submits that
the pro forma opposite parties are not contesting opposite parties. The issue notice to OP number 4 by speed oblique registered post with AD. Requisites for issuance of notice within
3 days.
Within 3 working days. List after SR. এটা রিট হয়ে গলা এটা আপনার ইস্যু নোটিস পার্টটা রিট ইনসর্ট হয়ে গলা তারপরে আইএ লিখন্তু আইএ 2677 of 2025 had learned counsel for the petitioner, then the learned DA সেটা পুরা কমপ্লিট করে দিলে নোটিস পার্টটা সমান রইলা accept one set of process fee as well as postal requisites for issuance of notice to the opposite parties. Opposite party number 5. OP5.
Only 4.
4. OP4. Then para, sub-para. As an interim measure, it is directed that status quo as on date shall be maintained. Status quo as on date regarding nature, character, possession, ownership of the property. Quoted description da konto?
Bottom of the petition, my lord, page 3 of the IA, my lord. Schedule of property I have mentioned. And I have also mentioned,
that is same as paragraph 3.
Paragraph 3, my lord. Paragraph 3 of the read petition.
Of the conduct. Involved in the litigation as per the schedule. Schedule টা আছে পেজ 3 রে পুরো কোট করে দেবে তারপরে সব পারা করি কি shall be maintained by the petitioner as well as the opposite parties till disposal of the writ petition. কিতে লিস্ট কেবে করছেন সেটা So list after SR, liberty to mention for listing before the assent bench. The learned AG shall obtain instructions. Yes. Yes, next.
16.
16, 16, 18 and
16, 18 and 19.
19. 16 re neichanti Mr. Datta neichanti. 16 Mr. A. Swain, Mr. Devraj Mahanti. 18 Mr. A. Swain and Devraj Mahanti. 19 likhibe Mr. A. Swain on behalf of SP Jenna for the petitioner. Mr. Devraj Mahanti AGA for the state. The appearance hela order ta Mr. Datta neichanti hela seta oda adjournment order achi se jo assignment upare achi kali jota karthile. Yes, next please. 17 pass over kar diyantu. Yes, next.
20.
Mrs. S. Biswal, Sonita Biswal. Yes, please adjust the microphone. Tol kar diyantu, pura kol kar diyantu. Yes, bend it more. Yes.
Here the petitioner challenged the award passed by the London District Forum. Here, your lordship, before I start my read petition, I would like
State Commission function koru nahanti.
No, function koruchanti. What happened in this? We went up to National National Consumer Forum. There, my revision was dismissed because of delay. There was 6 days delay. Here, the petitioner's deceased father took a policy and by suppressing the material fact that he was suffering from a liver disease.
No, the question is, Mrs. Biswal, that against the order of the commission, why you have not gone to the Supreme Court?
Because it is because REIT is maintainable
against order of the National Commission. No, check the act.
In National Commission, I have filed a revision because there was a delay. So
anything, any order passed on merit, you have to challenge it in Supreme Court.
I will Right, I will verify it, Your Lordship.
I was assisting your senior in that matter where against the order of State Commission, the appeal was filed. I had to go to the National Commission. It's a coincidence. I had briefed your senior in some matters, or your senior was engaged by my senior. So in those matters, I had to go because he did not go to the National Commission. I had to go to National Commission, and in fact, that is reported.
I will verify it, Your Lordship.
Thereafter, that matter went to Supreme Court. Supreme Court dismissed the appeal. The other side went to Supreme Court. And obviously, National Commission should not be, I think, when it becomes it's a complicated situation. If the High Court's exercise jurisdiction against the National Commission, then what is the use of having a National Commission? It can be the Central Administrative Tribunal. So High Court, then Supreme Court. So CAT has different benches. But each state is having a state commission. Please examine that. When do you want?
After 2 weeks, Your Lordship.
I mean, you can come up tomorrow also. It's up to you. I don't have a problem, but you have to obtain instruction or what?
Here, what happened, Your Lordship? This is a brief engaged by the Delhi law firm. There is little mistake. They have not annexed the State Consumer Award as well as the National Consumer Award. So, although they have mentioned it that they have filed an appeal, but they have not.
The Learned Counsel for the petitioner submits that she requires instructions to advance arguments. I'm not recording. That because then I spread for list after 2 weeks. I'm not recording to the extent that revision has been dismissed by the National Commission. Yes.
21.
With Your Lordship permission.
Other matter?
Your Lordship, the other matter which
it is submitted by the Learned Counsel for the petitioner that WPC number so and so is arises the same issue is connected.
Connected, neither the arising out of state. It's a different award passed by the Permanent Lok Adalat.
Then it's not connected to 20.
No, not connected.
Then you file it in the registry. Because it doesn't look good.
Your Lordship.
Because it's assignment of some bench. I haven't given all the assignments. So.
Your Lordship.
Yes, please.
21.
Mrs. Saraswati Senapati. A Senapati for the petitioner. Mr. Sarat Pradhan. AC for the state. Yes, Mrs. Senapati, please.
This is under Regulation 3B of Orissa Regulation of 1956 matter. Present petition is the owner of the land pertaining to number 36 as mentioned in paragraph 3. And due to non-submission of Form 2, my lord, before the opposite party number 2, present proceeding initiated against the petition.
You have checked the writ petitions decided by this court. There are a series of writ petitions. You check those decisions. I am issuing notice, but always prepare thoroughly. Yes, he can assist you. So both of us have been appearing in so many cases. Yes, Justice BP Das judgment, Justice Sanju Panda's judgment, sitting all sitting in division. Make an effort. The petitioner had Learned Counsel for the petitioner. The petitioner is agreed by the order. Impugned order? Agreed by the petitioner alleges. The petitioner alleges inaction on part of the opposite parties to accept form number 2 under section 3 into bracket capital A of the regulation 2 of 1956 as amended till date. Apano averment कोठी नेले apply कले बोली को paragraph रे. Which paragraph you have stated that you have applied?
I want to apply for Lady had no knowledge about the program.
Kindly speak to the microphone. Mother Subhuni actually, because of the glass barrier.
Petitioner had no knowledge about regarding the provision of law.
No, kindly look at the prayer. Kindly look at the prayer. Direct the opposite part number 2 in sub-collector Malkanagiri to accept form number 2. So how do you initiate that proceeding? Unless you apply or there is a proceeding or something. So say it upon a
Prayer for Lordship's direction to.
No, I can't direct unless you apply there.
No application there.
ଆପଣ ଆଭରମେଣ୍ଟ ନେଇଥିବେ କି ନହେଲେ ଗୋଟେ ଆପ୍ଲିକେସନ ଦେଇଥିବେ ଯାହା ବି ଗୋଟେ ତ ଉପରେ have to refer to that. How I will direct them to obtain instruction also.
File.
Again?
There is still I will file that form.
नहीं ଆପଣ don't be in a hurry to say. ଆପଣ verify କରନ୍ତୁ.
No, ma'am.
Day after tomorrow.
Se applying କରିନି.
Then it becomes speculative. ତାଙ୍କର ଇଚ୍ଛା ହେଲେ ସେ ଆପ୍ଲାଏ କରିବେ ଇଚ୍ଛା ନହେଲେ କରିବେନି ଆପଣ ସେ ଯଦି ଇଚ୍ଛା ହବ ଆପ୍ଲାଏ କରିବେ ତାପରେ ତାଙ୍କର ଇନଆକ୍ସନ ଆନାଲାଇଜ କରିବା I can say that since you have applied and they are not functioning he will obtain instruction but he says that there is no application you have heard him
Notice ଆସିଲା ପରେ ସେ
ଆଜ୍ଞା
notice ଆସିଲା ପରେ form annexure 4 cell notice ଟା ଆସିଲା ପରେ ତ ସେ
No you see if you are challenging the cell notice that's a different prayer if you want permission 3A जो अच्छी सेटरे अलगा prayer so you make up your mind काली आसवे ना पर दिन sorry
Lordship's desire
अरे मोर it's not my desire मु तो एपडू पळे आसले कोन करिया अदरे जाय कोटा वासी स्टडी
tomorrow
आज prayed for list tomorrow the sentence is complete हेनी और फिर पढ़ी दियंतु Stop. The learned count. It is submitted that the petitioners requires further instructions to advance arguments as prayed for. List day after कर दूच. List day after tomorrow. आपण जाय कि देखंतु brief टा consult करंतु. You talk to your the client. So then you make up your mind to withdraw because it may act as res judicata also. It is a serious thing. Withdrawing a petition has its consequences. Day after tomorrow. Yes. Next.
Noted to
Mr. Amit AP Bose for the petitioner, Mr. Sarat Pradhan, ASC for the state. Yes, Mr. Bose.
My lord, here, your lordship may kindly turn to page 12.
Yes, please.
My lord, the appeal was dismissed only on the ground, your lordship will see, the appellant, second line, the appellant fails to produce genuine documents in support of her claim. Second line at page 12.
These are it a type he paribani.
That certified copy to iya dounchen.
But no, High Court rules to achina upon neat type copy depe. No, but no, the handwriting is very good. Podi hoji.
The
that's to say jo apanakara local inquiry ra ita difficult.
Local inquiry ko mo jauni.
Acha.
So the question is that she failed to produce the documents for which the claim was rejected.
You are reading page 12, which line?
Second line, man.
Second line.
The
appellant fails to produce, yes, right, genuine documents
in support of her claim, since the court, thereafter the appeal was disallowed. But under annexure
this order is not appealable.
No, it's an appeal order. It's an appeal order.
No. There is no further appeal or revision review kichi nahi.
No, review achi. There is an application to recall that order also. That can be filed. I have filed that application to recall that order. Your lordship will see annexure 1 at page 8.
Yes.
This I have filed.
That's rejected.
No, that has not been taken into consideration. It is pending since 2006.
Obtain instruction.
My lord, your lordship may only direct to consider by
there is a purpose. Suppose it is misplaced or something, let them take a stand so that the petitioner doesn't wait for the for infinity. Already 21 years.
Yes.
Petitioner comes to High Court. High Court again sends him to the authority. Authority doesn't know where is the petition.
My lord,
at least something petitioner should get. So just give them some time. You have waited for 21 years.
Yes.
Let it be 21 years to 2 weeks.
Yes.
Mr. AP Bose, लिखिले. Sarat Pradhan लिखिले. Hybrid mode लिखी तब लिखो. It is submitted by the petitioner. It is the hard learned counsel for the petitioner. It is submitted that the petitioner raises a limited grievance regarding pendency of the appeal case number 28.
No, madam. Recall application.
Okay. The regarding the pendency of the application to recall, order data koti achi?
I guess 7-10-2010.
Where from you are getting it?
Your Lordship will see page 11.
Page 12 re.
12 re pronounced 7 October 2005. Last line.
7/10/07.10.2005 passed by the opposite party, settlement officer Cutter.
Settlement officer Cutter.
OP number?
But he is OP number 3.
Into bracket OP number 3. In
appeal case
number 282 of 2004.
4.
Pending OP number 2.
They submitted after filing of the recall of petition on 5/1/2006.
Yes.
On 5/1/2006, the petition is kept pending before the additional sub-collector, settlement Puri. OP2. Para. The learned AAC is directed to obtain instructions from the appropriate authority, into bracket IES authorities, regarding the regions of such a long pendency of the petition and the reasonable time that would be required to dispose of the same if the same is still pending and if there is no other legal impediment. How much time, Mr.?
3 weeks time, madam.
The learned AAC 6 for 3 weeks time, list after 3 weeks, liberty to mention for listing before the assigned bench.
May I say one thing?
Learned private party ochanti ki?
Private party darkar nahi. He is my vendor.
It is submitted by the learned counsel for the petitioner that the OP number 4
is my vendor.
Is the vendor of the petitioner and is not a contesting opposite party as of now. No notice be issued for the time being to the OP number 4.
Lord, I only pray if your Lordship may fix a date subject to your Lordship's
No,
time.
because you can mention it tomorrow. That extra effort you have to make to filing a memo. I am granting that liberty. The only purpose, because I don't know, the assignment is different also. I have a mixed assignment. All assignments have been assigned here. So that is the other part. So you file a memo.
23.
Mr. J. Gupta for the petitioner. Mr. Sarat Pradhan, ASC for the state. Yes, Mr. Gupta.
Copy has not been served.
Copy nahi?
Copy nahi.
Copy already.
Se scanned copy re au douna anti pra?
Na aaj diya hun to am to likhi
Sir bhi nahi.
Se request question gote dei paribe? Achi?
aji to nahi.
Aigya?
Now there is
Acha, nahi kali dei paribe na ke?
There is no file also.
The AC it is submitted by the Learned Counsel for the state that a copy may be of the writ petition may be provided. The Learned Counsel for the petitioner is requested to provide an copy to the Learned ASC by tomorrow.
tomorrow in the counter value. See counter de diya hoji apanku douna. This is the problem.
That system has been stopped. So yes, when do you want, Mr. Gupta? Day after anibana out.
Day after tomorrow.
List day after tomorrow as prayed for.
Every case ଆମେ ତ ଦେଇ ଦେଉଛୁ ସେ ଏଜି ଲେଖିଦେଲେ ସେ ସ୍କାନ କରି ପଠେଇ ଦେଉଛନ୍ତି.
Correct, but that has led to a situation where voluminous briefs are being less downloaded.
जो फाइल भी नहीं और.
Anyway, अपन देखो अब चेक करो. अपन what लिखिए the learned AG submits that he has not been provided with a copy by his office.
नंबर ହେଲା ବେଳକୁ ସେମାନେ କହୁଛନ୍ତି ସ୍କାନ ରେ.
I told him that. He doesn't dispute that.
No. Main number is
Filing whenever it is filed, that mail please to be sent to the AG's office.
No, that is true.
But you have to download it. If you are using that paperless code, that's another thing. Otherwise, physical brief you have to download. You have to become paperless like me. Yes.
24.
Mr. AP Bose for the petitioner.
My Lord,
Mr. Sarath Pradhan, AC for the state. Yes.
my Lord, may kindly turn to page 13.
Yes.
A registered agreement to sell was registered by the sub-register office.
Yes.
Sub-register Khandagiri.
Yes.
Thereafter, a suo cancellation deed was executed by the
Vendor.
vendor.
It's a agreement to sell.
Yes, registered agreement to sell.
So what has been cancelled? Agreement to sell or sale deed has been cancelled?
No, agreement to sell has been cancelled.
It can be.
No, my Lord, there is a circular of the IGR. No registered document can be cancelled. Because, my Lord,
Kindly show that.
Yes. Your Lordship may kindly see page 33.
Yes, sir. 33.
My Lord may see regarding registration of cancelling deed of earlier registered sale deed.
Right, that's the subject. Yes.
Yes. I am to say there is no specific provision in the Registration Act 1908.
You straight away come to that paragraph.
Yes. Answer is, in the considered opinion of this court, there was a judgment of Andhra Pradesh High Court, which was full bench judgment, which was taken into consideration. If a person sells away the property belonging to other, it would certainly be a fraud on the statute. You would be adding insult to injury if such person is go to civil court and get the subsequent sale deed cancelled or seek a declaration. Be it noted here under the common law, as discussed supra, the title of the persons remain intact, even if the stranger conveys the title to another, which is ineffective. Then your Lordship may kindly see. But this power, page 34, but this power has to be exercised very carefully on appropriate cases. It is made clear that the registering authority shall not suo motu cancel the deed, but can cancel, but can register the cancellation deed presented by the true owner, but said suo motu commence prosecution. My Lord, I am on the submission before your Lordship that once a registered deed is there, it can be suo motu cancellation can be accepted, but the deed cannot be cancelled. And
No, Mr. Bose, here the things is different.
Yes.
The second deed is by the executor.
Yes. Then a notice has to be given.
So second deed has been registered.
Yes.
So your logic also works both ways.
Yes.
Second, there is no prohibition.
Just register it.
Just we are discussing. Just 1 second. Second deed declaring that the earlier deed is cancelled it has to be registered also.
It will be registered.
It has been registered.
It cannot be cancelled.
You are saying earlier has been cancelled.
Earlier one has been cancelled.
By which order?
By this second cancellation document which has been registered. Your Lordship may kindly see.
Look at page 33.
Yes. Yes, I am aware. Registration of cancellation deed of earlier registered sale deed.
So this circular
another document.
No. Let us first finish that. This circular dated 23/5/2011, does it prohibit registration?
Yes.
If it prohibits, then it is contrary to Registration Act.
No. My Lord, it cannot be suo motu cancelled. Your Lordship may kindly
It's not cancellation. You are saying cancellation by the executor or the registering authority. That I am asking you.
Cancellation by the registering authority on presentation of deed by the
Correct. Cancellation by which you show me that. You have not shown me. You have shown me two deeds only.
Yes, that second deed your Lordship may kindly see.
Second deed is a deed executed by the executor, not by the authority.
No. Your
So
Lordship
authority is duty bound to register it.
My Lord, he has registered an
agreement. The way you are reading, actually also supports the proposition that second has to be registered.
It has been registered.
Correct.
But can it be cancelled?
Which one is earlier one is been cancelled to show that?
Kindly to see page 26.
As far as the deed is concerned, the deed cancels, the executor cancels the earlier execution.
Yes.
That has been registered.
Yes.
But if you are saying that the registering authority has cancelled the earlier registration, so that by which order?
Kindly see, there is no order is required. There is no order required. I moved the IGR.
That proposition is not because.
Kindly see, my lord. Cancellation of sale agreement, page 26.
It has to be registered.
My lord, it cannot be entertained.
No, it has to be.
Because once
In Registration Act or the Transfer of Property Act,
yes,
show me any provision. Anyway, at the prima facie, you take notice.
my lord.
You are not you are saying that once a deed is executed by any executor, your essence of your argument is he cannot recall that. That's not correct.
No, my lord, he cannot recall. He cannot recall.
This circular, if at all you are interpreting, then the circular has to go.
My lord, that your lordship will ultimately decide.
You see the act of the registering authority to cancel is different.
Yes.
But act of the register, the executor of a deed to recall his execution is different.
No, he cannot.
He can. The consequences, you may say, is different. But the authority who is registering cannot enter into the merits of the execution and say that this is bad, this is good, unless it is illegal. Suppose it's a agreement by you where he will beat your junior. Agreement between you and Mr. Pradhan, Mr. Pradhan will beat your junior. That the authority can provide because it is contrary to on the face of it.
Yes.
But a agreement to sell being recalled by the executor himself, we are saying it will not be registered.
It cannot be registered.
So anyway, it's a very, very vast proposition.
Yes.
Let us see. The hard learned counsel for the petitioner. It is submitted that the petitioner is agreed by the registration of the second registration.
Again, set out page 26.
Registration of the deed by the registering authority. OP number?
My lord, that is OP number.
Sub-register Khandagiri.
Yes.
Sub-register
4.
Khandagiri. Registration date ta kodi pauchandi? 26 re.
Date ta hochi 11/4/2022.
11/4/22. It is submitted that since the cancellation of agreement to sell as registered under 11/4/2022 as in effect cancellation of the earlier agreement to sell. Dekhantu.
Agreement to sell hochi annexure 1 at page 20.
Into bracket dated. Agreement to sell dated.
Agreement to sell dated is 15/10/2018.
15/10/18 into bracket annexure 1. The second deed cancelling the agreement to sell could not have been registered as has been done by the authority. It is said that the intending vendor vendor is the petitioner number 5. OP number 5.
Yes.
Apana kiye? Intending purchaser.
Purchaser.
The petitioner being the intending purchaser. As far as the deeds for registration, sale of property and cancellation of the sale of property are concerned. Issue notice along with this order. The policy upon advance copy served appears on behalf of opposite parties 1 TO24. Waives notice. Issue notice to OP number 5 by speed/registered post with AD. Requisites for issuance of notice.
Day after tomorrow.
Within 3 working days. Fixing early returnable date. List after SR. Liberty to mention for listing before the assigned bench. Yes.
My lord, I have filed an application that your lordship may say that it may be your lordship may issue notice on the interim application because there is nothing.
It is very smart as you. I was thinking that what you will submit because after so much of discussion, really good, very good strategy. IA 5242 of 2025. Because when I asked you this question that how you the registering authority will not register, you will not press the IA. I realized. IA 5242 of 2025 issue notice as above. I got hard learned counsel for the petitioner. Hard learned counsel for the petitioner issue notice as above. The learned AAC appears on behalf of the opposite parties. Repeat kar debe. Issue notice to OP number so and so. Repeat. Accept one set of process fee as well as postal requisites for issuance of notice. Just after SR, the prayer for interim order shall be considered on appearance of the OP number 5. OP 5.
Gratefulness.
Liberty to mention for listing before the assigned bench. Rest of the matters after recess, any mentions or any urgency?
Pardon to mention, my lord.
Yes.
Item number 6 is pass over, my lord. So I pray that the advocate for the petitioner is not well. So maybe
6 kouchandi.
Yes, my lord. 1 week after.
pass over tale apon dakichandi?
No, 1 week after I pray, my lord.
Acha ठीक अछि. Tale pass over apon after the
6 is 1 week.
Apon ko naata sir?
NK Das.
NK Das.
My lord.
Mr. NK Das on behalf of BK Mohanty. Item 6 lekhantu. For the petitioner, Mr. Sanjeev Swai, AGA for the state. Adjournment is sought for by the Lord Counsel for the petitioner due to personal difficulty. As prayed for list after?
1 week after.
List after 1 week, liberty to mention for listing before the assigned bench. Any other mention? After the recess.
Pass over item 17.
None appears for the petitioner, though the matter is called twice over. Once when it reached, and again after resumption of the proceeding, after recess, after lunch break. To grant further opportunity, the matter stands adjourned. 17, Mr. Mohanty.
My lord.
Petitioner none, Mr. Devaraj Mohanty, AGA for the state. List after 2 weeks, liberty to mention for listing. List after 2 weeks, third liberty to mention for listing before the assigned bench. Next, please.
25.
Mr. PK Satpathy. Passover is over, na?
Passover.
Mr. Satpathy, please. PK Satpathy for the petitioner, Mr. Sarat Pradhan, AAC for the state. Yes.
Present petitioner has purchased a
Kindly speak to the microphone. Talu kar diyantu. Pura talu kar diyantu microphone ta.
The present
Tara stem ro base ru talu karo actually.
Eta.
Right. That would help you. Yes.
The present petitioner challenged the order of the revisional authority.
Yes.
In rejecting the revision petition by giving some observation regarding the validity of lease granted under the OGLS Act.
It is not applicable order.
Not applicable.
And so the paragraph where you were agreed, any finding?
The page 18 is the order, madam.
Yes, please.
The case is taken up today. The learned.
No, I mean, I don't want to see the entire order. You just show me the paragraph where you find, you are aggrieved or you find that there is error.
The bottom, the Jawan lease, madam. The Jawan lease.
You are referring to page, sir?
Page 18.
18, yes.
I have purchased the land from the Jawan, the leasehold land, part of the leasehold land. The so-called Jawan leaseholder had done a plotted scheme to sell the leasehold land on commercial basis. the Jawan lease granted by the Revenue Disaster Management Department such and such, and Revenue and Disaster Management letter number such and such is for agricultural purpose only. This is clear violation of the very purpose of the grant of the lease. The learned standing counsel present at the court vehemently opposed the maintenance of the case. The petitioner submits that though he had attended the last settlement operation, his claim for recording the suit land has based on RSD was rejected by ASO. Notice were sent to opposite party by registered post for hearing, but no objection has been received till date. The petitioner has not submitted a certified copy of Jawan lease case, the order of revision authority, ADM Bhubaneswar, and the order of the Hon'Ble High Court of Orissa. As a result, it is impossible to establish the flow of title, the suit land in favor of the petitioner. Perusal of Hal Arwar reveals that the suit land is government khata as abad jogya anabadi.
No, you आपण माने ऑर्डर टाको फेवर करछन ना डिफेंड करछन ना अपोज करछन
अपोज करछी
किछि गोटा अपोज कला भला किछि कहंतु ए तो सब ठीक अछि
that part this is the order. The settlement authority should not go to the merit of the lease case. And
this is ordered by a tahsildar, not settlement
by the settlement additional commissioner. This order by the additional
commissioner settlement
authority. The proceeding was posted on 4th March 2024, page 16. On that date, direction was issued to submit the document on 27th March 2024. On 27th March, again, in the court, there is a page 16.
Kindly refer to the order sheet, page 16. Yes.
The first order, 4th March 2024.
Posted to Satish.
Yes. On Satish, there is a direction in the court to submit the order of the ADM. And order of the court. But after when I have applied for the certified copy, that order has been struck down and the final order has been passed. This order of the certified copy, I am not able to produce the order sheet of the Hon'Ble High Court.
27 दिन परे कोर्ट थ्रू हे गला तापरे
सेम डे फाइनल ऑर्डर पास हे गला रिजेक्ट
सेटा कोन आपण लिख देथिले कि
ना सेटा ताको
आपण जूनियर लिखथिले
से ताको अथॉरिटी सर्टिफिकेट कॉपी हम मानछि देखि सर्टिफिकेट
हैंडराइटिंग मिसुनी ए आपण हैंडराइटिंग भले लागुछि
आगे मु करथि लिखि सर्टिफिकेट आई डोंट नो सर्टिफिकेट कॉपी रे मु आनि छित दे हैव
अभी तो प्रधान लिखछन ना कोन who has written and scored it through
27 दिन मते कहले डेट टाइम पर जो बुझिएको पर बुझिबे गेल तो फाइनल ऑर्डर हे जाईची रिजेक्टेड मु रीट पिटिशन सर्टिफिकेट कॉपी फाइल करची रीट पिटिशन संगे
passed in Miss Case number 329 of 2023 divided by Miss Case number 92 of 2023.
OSS.
Sorry?
OSS 92 by 22. OSS case 92 by 22.
Let me see. Could be.
OSS 92 by 22.
ओडे ए कौन लिखा है ना एम लिखा है 18 divided by OSS number 92 of 2023 in a proceeding under section U/S-15 into bracket small b of the Orissa Survey Settlement Act 1958. It is submitted that the revisional authority under the Survey Settlement Act could not have gone into the aspect of आपण कोटा जीवा कथा न कहउछन
lease validity of the
lease granted to the predecessor in interest of the petitioner. Para without prejudice to the aforesaid contention, it is also submitted that the petitioner did not have any opportunity to present his case, as would be evident from the certified copy of this order, that on 4/3/2024, into bracket annexer,
One minute.
annexer 1,
Again, order.
the matter was directed to be listed on 27/3/2024, also directing the petitioner to file Sabi Karwar, plot index Sabi Karwar, देखी लिखि परिवे बड़ा page 16 रे अछि Sabi Karwar, plot index, as well as postal requisites. Thereafter, on 27/3/2024, and it is submitted that 27/3 is the next date, and the matter was not taken up prior to that, the application was finally disposed of on merits. Issue notice along with this order, the learned ASC, upon advance copy served, appears and waives notice on behalf of the opposite parties. Appears on behalf of the opposite parties 1 TO2
1 to 6 and 8.
6 1 2 TO2 6 comma and 8.
7 maybe wait for the time.
The learned tapar lekhibe issue notice to the OP number 7.
7 may be waived. 7 may be waived, my lord. The purchaser, the vendor of my.
It is submitted, that will be at your risk. It is submitted by the learned counsel for the petitioner that the OP number 7 is not a contesting opposite party. He only being the vendor of the petitioner, and the petitioner does not have any claim against OP number 7 as far as the present writ petition is concerned. The learned AAC shall obtain instruction and file counter. He seeks for how time?
4 weeks time.
He seeks 4 weeks time. List after 4 weeks. Liberty to mention for listing before the assigned bench.
I have filed IA.
IA 5084 of 2025. IA कौन चाहते?
To maintain the status quo over the land.
Hard learned counsel for the petitioner. Issue notice as above. Learned ASC appears and waives appears on behalf of opposite person, and so पूरा repeat कर देवे सेटा. Just reproduce that. As an interim measure, it is directed that status quo regarding ownership, nature, character of the property, as given in the schedule dashi to the IA, page marking. Second page rachi. Moja andharwa, so and so पर लिखी देवे. Moja andharwa to neki plot number 2076/3263 shall be maintained by the petitioner and the opposite parties till the disposal of the writ petition. Liberty to upar dechanti, I am liberty to mention now. Yes.
26.
Mr. Pradhan and Mr. Mahanti, wherever this kind of situation where it doesn't require adjudication, suppose he agrees to be remanded to the additional commissioner because of that next date it has been disposed of. What he shows is that one date, distance of this thing, produced so and so document, disposed of. So there, don't keep the matter pending here because the petitioner doesn't get anything. So you obtain that instruction. Yes.
Item number 26, I am appearing on behalf of Mr. Jajati Keshari Khuntia.
Yes.
In this matter,
your name?
Sai Suman.
Miss Sai Suman, SAI, Miss S. Suman, SUMN, on behalf of JK Khuntia for the petitioner. Yes, please.
Your Lordship, in this present content petition, the petitioners had filed a writ petition.
Yes.
Directing the opposite parties not to remove the soil from the adjacent land that the petitioner have in their control.
That's an interim order or a final order?
Final order, Your Lordship. A writ petition number 21835 of 2024.
Yes.
This Honorable Court was pleased to pass an order to consider the grievance of the petitioner by the opposite parties. The order was passed on 27/9/2024. it was communicated to the collector's office, Your Lordship, and after that the collector had written a letter to the superintendent engineer R&B.
Just kindly look at the order dated 27/9/2024, which you are saying that it has been violated.
Yes, Your Lordship.
Which part is violated? Please.
They have not considered the grievance of the petitioner in any way, in any case, and the collector, even after.
Kindly just look at the petition, then you can concentrate.
Yes.
Look at the order. Which part you are saying has not been complied with?
Your Lordship, last paragraph 5, last, or the opposite party shall do well to consider the grievance of the petitioner and dispose of the representation in accordance with law, directing for suitable remedial measures as expeditiously as possible. After that, this order was communicated to the collector's office. The collector, Baleswar, then wrote a letter to the superintendent.
Because you had made a representation, you have that copy of the writ petition.
Your Lordship, right now
You should have, because you see, I am holding both. That is how there is a gap between our appreciation. Because the court, you also must mark that there is no expression of opinion on merits. It is you are seeking a direction, and para 5, kindly read para 5 of that order.
In view of the limited nature of grievance, the petition is disposed without issuing any further notice to the opposite parties.
So why that observation? They were not heard. Because fairness demands that both the parties are treated equally. Anyway, you are saying that the representation, because you are not having the copy of the writ petition, the representation was dated 17/7/23 or 9/6/23, which was pending and not disposed of. Can you check the details? Can let it be listed tomorrow, or you want list?
Yes, Your Lordship.
Because I can't ask them to obtain instruction, because
Your Lordship,
the learned counsel had learned counsel of the petitioner. She submits that she requires further instructions to advance arguments. As prayed for, list tomorrow or day after?
Tomorrow, Your Lordship.
List tomorrow. Just check the representation what you are referring. And whenever you are addressing on a contempt, please be sure of the writ petition. And well done. You have done well. Don't be apprehensive. But also, please mark the tenor of the order. The order is passed without consideration of anything, without issuing notice to the opposite party. Simply that the representation of representation. But yes, they have to dispose of. Yes.
27. I may please, Your Lord.
Mr. S.C. Acharya for the petitioner. Mr. Mr. Pradhan, you are there. You have marked the noting in the list.
Yes, that is
limitation file है नहीं?
Limitation sir से कौन है जी? Your Lordship has given a direction, Lords, to review the order within a period of 60 days, and accordingly within prior to that, Lords, I have filed the application, Lords. But it has been, I think, it is wrongly.
Prior to 60 days, you have filed.
Yes, Lords. Trust me, kindly see, Lords.
S.C. Acharya for the petitioner. Mr. Sarat Pradhan ASC for the state. बाईस से 28 ଆପଣ କେବେ ଫାଇଲ କଲେ?
ମୁଁ ସାର୍ ଫାଇଲ କଲି 17/10/23 ରେ।
Mr. Pradhan, you are having that copy? ଆପଣ ଆନେକ୍ସ କରିଛନ୍ତି କି ସେମ୍ ଏପ୍ରିଲ ରେ?
ଆଜ୍ଞା।
ସେ WPC ଟା ଅଛି ଆପଣଙ୍କ ପାଖରେ?
Yes, my lord.
WPC ରେ ଅର୍ଡର ଟା ଅଛି ଆପଣଙ୍କ ପାଖରେ? ଅର୍ଡର ଟା ଦେଖନ୍ତୁ।
Additional Cabinet Council for the state. Submission as noted in
just kindly use the mic. ଆପଣଙ୍କ ମାଇକ୍ରୋଫୋନ ଟା ସିଆଡେ ପଳେଇଛି, ଆପଣ ପାଖକୁ ନେଇ ଆସନ୍ତୁ।
as noted in the order dated
ଆପଣ ଲାଷ୍ଟ ପାରାଗ୍ରାଫ ଟା ଦେଖନ୍ତୁ। 3.
Para 3, having heard the Lord Additional Standing Council, the writ petition is disposed of, granting liberty to the petitioner to revive the same within a period of 60 days for any surviving cause of action.
Yes. Surviving cause of action किछ अच्छी?
Sir, अच्छी कहीं ना
अच्छी बहुत अच्छी। Now the next point, actually why I was drawing your attention, this order is 22/8/23.
My lord.
He says that the petition was filed on 10 17/10/23.
17/10/23.
So there is no delay. 60 days to hi nathila. So that noting would has to be ignored. I am restoring it.
Madam.
Upon data filing data could dekhundi Mr. Acharya. 17/10 presented on. CMAPL order likhe. CMAPL say 736 of 2023 appearance लिख लेता से जो इतने hybrid mode लिख ले तापर लिखंतु the learned counsel for the petitioner draws attention of the court to the order dated 22/8/2023 passed in WPC into bracket TA all capitals number 117 of 2017 while this wherein the writ petition was disposed of granting liberty to the petitioner to revive the petition within a period of 60 days for any surviving cause of action. It is submitted that the petitioner has filed a petition to revive the case. Upon the CMAPL किए file कला? Review. Statement से ठीक कर चंदी? से ठीक कर चंदी? अपना miscase file कले? CMAPL limitation कितने? 30 days.
30 days.
से ठीक कर चंदी?
Miscase भी 30 days.
अपना कौन क्या था? लिख लो. On 17/10/2023, they submitted that, however, inadvertently, instead of filing the miscase for revival of the petition as per the liberty granted, upon liberty da use no kari ke upon CMAPL file kar dele. So se ठीक कर चंदी the registry.
30 days.
30 days. कौन लिख ले? हाँ. The petitioner has inadvertently filed a CMAPL which was supposed to be filed within 30 days within the period of limitation. It is submitted that the court may take a lenient view to treat the same appeal as the prayer made therein is to treat the prayer made in the same appeal as that of a miscase and restore the petition. Para, the learned AC submits that since the petitioner has filed same appeal, it was filed beyond 30 days. The registry has correctly pointed the delay in filing the same appeal, for which it is also pointed that no petition for condonation of delay has been filed. Para, having had learned counsel for the petitioner and the learned AC, in the considered opinion of this court, taking a lenient view, the delay is the writ petition, the same appeal is allowed. The writ petition stands restored to file. The same appeal stands disposed of.
May I please?
Mr. N.K. Barik for the petitioner. Mr. Devaraj Mahanti, AGA for the state, for the opposite party. Yes, Mr. Barik.
Petitioner having been neglected to get IAC period scale.
So, what is the order dated 8th of May 2024?
Milord, Lordship, paragraph 1 I have quoted. Paragraph 1 at page 2 of the contribution. The second paragraph, order number 1, 25/10.
What is this further affidavit? Kindly show that.
Further affidavit I have made. They have disposed of the representation. What they did, they made some discrimination with me.
So you challenge on merits?
No, let me suggest that.
Please, please.
Whatever in municipal high schools.
Mr. Barik, you make submissions. I have no difficulty.
Yes.
In fact, enough time would be there for you. But you must understand that you are on a road to something. If you are addressing the merits of the disposal, it cannot be taken up on contempt petition. You know the well-established position of law. So regarding merits, this court has a limited jurisdiction as far as contempts are concerned. But if you want to challenge the order, you challenge it.
No,
So that you achieve something.
I know it. Question is, this is the second contempt.
Even if you know that, suppose you know that,
Your Lordship,
should you not take a view?
Fortunately, Your Lordship have passed this order.
No.
The repetition, Your Lordship.
That is the assignment. Otherwise, it would not have been come to me.
25th October 21, my Lord, while sitting on the bench.
Don't rewind things, Mr. Barik. Let us not waste time. You are saying the order passed by the authority disposing the representation is discriminatory.
Yes, Miller.
So that is you are addressing on merits.
Right.
So contempt jurisdiction, I cannot take that up. I cannot ask them. But in a writ petition, I'll ask them that you file reply.
I'll file. Let them. If they have not filed also compliance affidavit till date.
How can it be? Suppose I know that you yourself saying that it has been disposed of. So if they filed, it will be for more time will be taken. How can
Order has been communicated. Order has been communicated to you.
That's it. So that he's saying.
This contempt is pending.
Mr. Barik, if it is communicated to you on your own showing, then there is no need for filing up contempt.
I have no objection.
It's not a question of objection, sir. You objecting is not important. You also must understand that the petitioner has a cause of action.
Yes.
That should be redressed.
Your Lordship may make that observation. I'll file.
You obviously should have filed.
Yes.
Or you may. One cannot be compelled to file a petition, but if you want to challenge, you challenge it. What is the difficulty?
But this order itself is discriminatory. I'll show. If Your Lordship want, I'll.
Why should I want? In a contempt petition, I will address on merit so that they will challenge it in the writ appeal. Appearance लिख लीजिए. Nagan Barik and Mr. Devraj Mahanti, the learned counsel for the petitioner, submits that he has filed further affidavit dated 16th May 2024, indicating that
This was filed due to this discrimination I have filed. I have given some instances. There are 3 letters I have annexed.
सेटा रीड न करिके एटी फाइल कर देले अच्छा चल नहीं I am not dealing with that. I thought that say out a contact. Only the petitioner alleges. Hard learned counsel for the petitioner alleges non-compliance of the order passed by this court dated 25/10/2021, disposing of the writ petition number 31481 of 2021. It is also fairly stated by the learned counsel for the petitioner that the petitioner has been communicated. Upon communication da court file kale affidavit re.
Further affidavit
the petitioner has been communicated by order dated
8/5/24.
Has communicated the order dated 8/5/2024 as would be 8/5/2024, disposing the representation as would be evident from the additional affidavit. Now, key affidavit. Further affidavit filed by the petitioner after receiving the order dated 8/5/2024. It is submitted that the affidavit has been filed by the petitioner to indicate that he has been discriminated. Affidavit has been filed. Affidavit dated 16/5/2020. He has been discriminated. Learned AG in response submits that the order passed by this court has been complied with, as has been fairly stated by the learned counsel for the petitioner. The order disposing of the representation of the petitioner is enclosed to the कोडे गला से ऑर्डर मिलुनी
I thought they might have filed, but they are not. Now I am filing.
ठीक है छड़ दियो कौन लिखे
दे दो जो अच्छे
कौन लिखे stop it is in view of the compliance of the order passed by this court nothing survives like it's not required he's not you are none of you are disputed nothing survives for adjudication the petition stands disposed of regarding the petitioner being aggrieved by the order dated 8/5/2024 he shall seek his remedy yes
may say that content proceeding is dropped
yes first court order लिख ले in view of in view of the also देखिए पढ़ियो ना in view of the compliance of the order passed by this court nothing survives for adjudication the content petition is dropped तापर पैराग्राफ कौन लिखिले regarding the contention that the petitioner is discriminated by the order dated 8/5/2024 the petitioner shall seek his remedy yes next
Urgent.
it's uploaded all the orders are uploaded
29 I pray
urgent certified copy as per rules कर दिया
29 I pray for Miller's 2 weeks time I'll comply that
Mr. Dipti Ranjan Mahapatra this is an order passed by this bench
yes
Mr. Dipti Ranjan Mahapatra for the petitioner Mr. Devaraj Mahanti AGA for the opposite party you have verified this they are not no more I think you have to change the opposite party the notice will be incorrect
notice was already issued however
now
change the party yes the secretary now
you have to because it is a contempt is a quasi criminal
yes sir
nature so you have to make the proper party कौन लिख ले हाजिरा लिख ले appearance लिख चली the learned counsel for the petitioner seeks accommodation to obtain instruction regarding the present incumbency of the opposite parties and stop he submits that he may be granted liberty to substitute the officers who are designated at present or who are incumbent at present. It's how much time?
I can do within 1 week.
Sorry?
Within 1 week.
List after 1 week? ଆପଣ ଯଦି କପି ଦେବେ ତାହେଲେ anyway ଆପଣ ଦିଅନ୍ତୁ ତାପରେ instruction ନେବେ
I am substituting I am doing complying the requirements as in the meantime so cause affidavit because
the problem is that you have not made the proper party
no at the time of
you should not leave these loose ends in your petition
I have
in a order to expedite the matter don't leave these loose ends
that
because you know it they are made why they are named in person that's the other part of it so
who was party
I think today you should have moved I thought that you will be moving this for substitution so list after 1 week liberty to mention for listing Mr. Mahapatra he may unofficially intimate them that's a different thing how the court will direct these opposite parties to provide instruction they are no more holding those posts that you must also appreciate you can request your friend to obtain instruction that's or he may as a principal he may obtain instruction in content matter
that was another order
fair enough I have that order have I recalled that order no. Then yes
30
Mr. S.C. Das for the petitioner
May I please, Your Lordship? My Lord, in this
Mr. Sarath Pradhan, AC for the state.
My Lord, in this writ application, the petitioner is praying for a direction to the Tahsildar Yamuna for settlement of Bhutan land, my Lord. By the order dated 28/2/25, Your Lordship directed the London State Council to obtain instruction in the matter as to apprise this Honorable Court regarding the time that would be taken for disposal of the case pending before the authority.
Right.
In the meantime, the Tahsildar has filed one affidavit before the
Yes.
court.
Yes.
They are paid for 4 months' time,
My lord.
to dispose of the case, my lord. In
Uh,
9 of para
kindly
9
refer to the paragraph.
Para 9 of their affidavit.
Yes. 4 months time.
That in the aforesaid facts and circumstances, 4 months time
The
also be allowed.
Hard Learned Counsel for the petitioner. The Learned Counsel for the petitioner refers to the order passed by this bench, by this court, dated 28/2/2025. The paragraph 3 of the extract of paragraph 3 of the said order is reproduced herein. Hela? Extract of paragraph 3 of the said order is reproduced herein. Quote korantu. Late adequate number of extra copies to neki before the authority. In response in obedience to the said order, affidavit has been filed by the opposite party numbers 2 and 6.
2 and 6.
Copy of which has been served on the Learned Counsel for the petitioner. The Learned Counsel for the petitioner refers to paragraph 9 of the said affidavit. The Learned ASC referring to the affidavit submits that the period that would be reasonably undertaken for disposing of the case by the Tahsildar has been indicated. Para. Having had Learned Counsel for the parties, considering the affidavit filed by the Tahsildar, OP number 2. OP 6. The writ petition is disposed of, directing that the Tahsildar shall abide by the undertaking given in the affidavit, and the petition shall be disposed of. April mas chalchi. May, June, July, August. By end of August 2025. The petitioner shall produce a copy of this order obtained from the website, /certified copy, before the Tahsildar to act upon the same.
Right.
The Learned ASC shall intimate the Tahsildar to do the needful.
Right.
Yes. The writ petition stands disposed of. Yes, please. Next. Petitioner none. Mr. Devraj Mahanti, AGA for the state.
It's a 1 month arrive. Right. I'll take it.
Learned Counsel for the petitioner, none appears for the appellant. Petitioner, no, appellant. How? None appears for the appellant when the matter is called. This coordinate bench has had engaged the learned amicus in absence of the counsel for the appellant. Registry shall inform the learned appellant regarding listing of the matter. And amicus. Registry shall intimate the learned amicus regarding listing of the matter. The learned AGA shall obtain instruction regarding the whereabouts, present status and welfare of the appellant through the concerned IIC/IO to apprise this court. Stop. The concerned IIC/IO shall make an endeavor to make field inquiry to obtain the and provide instruction. Yes. Next, please. Please, how much time, Mr. Mahanti?
4 weeks.
List after 4 weeks, as prayed for.
32.
32?
May I please, Your Lordship?
Yes, please.
Sir, on behalf of my senior, I'm presenting this case, but actually, my senior is not well. Due to her medical issue, I need some time. Like, if you
But,
adjourn this matter, sir, Your Lordship,
you are on behalf of?
appellant.
Appellant, the learned counsel's name?
Sumit Lal and Janice Wallace. Actually, Janice Wallace is arguing this matter, and she's on medical issue. That's
no, because it shows Manoranjan Mishra. So that is how I was little bit.
Manoranjan Mishra and Sumit Lal, sir.
Achha.
But
what's your name?
Miss Subhashri Mishra.
Subhasri.
Okay, sir.
Miss S. Mishra on behalf of Sumit Lal for the petitioner. Are you in touch with the appellant? Any instruction?
Yes, sir. Her instruction just now. She said next week.
No. I'm not there. I'm not there. Regarding appellant Budu Murmu Madhusudan Rao.
No, Your Lordship.
What is his status at present?
No, Your Lordship. Actually, I'm new in this chamber, new associate. So I don't have any idea.
कौन लिख ले? Sumit Lal. Appearance लिख ले. Mr. Devaraj Mahanti, AGA for the state. Learned counsel for the petitioner, learned counsel for the appellant submits that Ms. Janice Wallace, who has been interested with the brief, is indisposed due to some personal difficulty. The matter may be adjourned. The learned AG is requested to obtain same order instruction. Complete kar debe. List after 4 weeks, Mr. Mahanti. Yes.
Obliged.
You try to contact. You can also, prepare along with your senior, Ms. Wallace or Mr. Lal, and argue the matter. But please be sure about the whereabouts of the appellant, because the principle is the appellant has to surrender to the jurisdiction of the court.
Yes, sir.
If he's untraceable, then it becomes difficult.
Definitely, Your Lordship.
Yes, please.
33.
Mr. Rupam Mishra, on behalf of B. Mishra for the appellant. Mr. Sarat Pradhan, AC for the state, respondent. Adjournment is sought for by the learned counsel for the appellant due to absence of the arguing counsel. The learned AC shall obtain instructions regarding the whereabouts, present status and welfare of the appellant through the IIC/IO to apprise this court. The IIC/IO shall make a field inquiry to provide instructions. How much time, Mr. Barik?
4 weeks.
I'm sorry, Mr. Pradhan. List after 4 weeks, as prayed for. Yes.
2 weeks.
से आरंभ रो मेंशन करछंती हियरिंग मैटर कोन करिवा अपन तो इन्फॉर्म कर देबे रूपम मिश्र को 4 weeks after.
34.
34. Appellant none, Mr.
Similar.
34. Appellant none, Mr. Sarat Pradhan, AC for the state. None appears for the appellant when the matter is called. Since the matter is of year 2000, the registry shall inform the advocate on record regarding listing of the matter.
Status.
You obtain status. The learned AC shall obtain पूरा complete कर देबे. डिक्टेट करिवे ना सेटा रिपीट कर देबे. आपण गोटे नेले ना What is Yantu? Yes, same order. Right. Yes, next.
35.
To obtain instruction after field inquiry. Apprise this court. Yes.
Status.
Call korantu.
30.
Call already. Mr. K. Sethi, on behalf of D.K. Patnaik for the petitioner. Adjournment is sought for by the learned counsel for the appellant in absence of the learned senior counsel. It is submitted by the learned counsel for the appellant that he is not with the appellant. The learned AC shall obtain instruction.
Similar.
List after 4 weeks as prayed for.
Manner.
Thank you.